David Ford.
Right to the podium.
Call in Emily. People against David Maurice Ford, 25W836-770A. Your name?
David Maurice Ford.
All right, so let me get probation in here. And let me see.
Oh, I'm sorry. Okay, thanks. All right, bye.
Or Sadie wants to. Sadie's gonna do it.
She's, yeah, that's who's coming in.
All right. Give me 1 second. She's making her way in here. I have currently a show cause that alleges that you failed to appear for weekly testing on August the 12th. And count 2, you failed to refrain from consuming alcohol or drugs, testing positive on a chemical test on August 13 of 25 with positive results for THC. And now there's a note here.
Briefers, we have Mr. Elter as standby counsel. We have Ms. Hyatt from the prosecutor's office. We are here today. The docket says video deposition of a witness, but that's not right. We're here just for a conference in advance of our trial set to begin in a couple of weeks, and we have a number of motions that are on the docket for today. Let's talk about the conference items first. We are set for trial, and I don't yet know whether we are first up for that date or not. I've not yet received the notification from Ms. Yazel as to whether or not we are first up on the 9th. My guess is we are, so I am going to proceed as though we are first up on the docket. So what that means, Mr. Reefers, is that the jury is going to arrive at 8 o'clock. They are going to check in. I think we've been through this once before, but I want to go through it again. There's a bit of a line at the door at 8 o'clock. Don't mix into that line. Wait till that line goes down, and then you can come on through. Do not have to go to pretrial services on the day of your trial. Just come directly to the courtroom. And then sometime in the 8:15 range, we will have the jury packet, which consists of all of the jurors that have been summoned for that day who are here, a seating chart, and the jury questionnaires. Those will all be provided to you by the jury commissioner or the bailiff. So you'll have a seating chart, kind of looks like this, that tells you where everybody is sitting. And in the bottom part where it says alternates, those are the people who will be called next up. We'll have some discussions probably in the morning around 8:15. They'll let us know. Usually it takes, the jury's usually checked in by 20 after or so. We'll call them down. The jury will be seated 12 in the box, and the remainder of them will be behind you. I have some opening remarks. I will go through the initial statutory questionnaires or questions to determine whether or not they are preliminarily eligible to serve on the jury. I will ask them some questions about their questionnaire, if they have prior law enforcement experience, if they have military service, if they've ever been a juror before. Then I will turn it over to Ms. Hyatt and give her 20 minutes for her initial voir dire. And then if she passes for cause, then she can let me know that. Then you have your 20 minutes to do your questioning of the jury. Then we will exercise peremptory challenges, first from the state and then by you. Then we put 2 new jurors in the box, and we will confine our questions only to them. And then we will have issues. You get your 4 peremptory challenges. We go till each side has exercised all their peremptory challenges or both sides pass. The last peremptory challenge I will generally do, I will let the state exercise their final peremptory challenge, put that person in the box, and then you can save your final peremptory challenge for the entire panel. We will seat 1 alternate, and we will have 1 peremptory challenge for the alternate. Opening statements, 15 minutes is good for opening, right?
It should be, Your Honor, close to that, yes.
Mr. Reefers, 15 minutes, good for openings?
Your Honor, before we proceed, I'm just asking for clarity. Are we here for an evidentiary hearing today
We are conducting our conference first, and then we're going to talk about your motions.
Okay, well then, if I may, can I submit, I've got a packet put together for today for the evidentiary hearing. What I've noticed, Your Honor, is some of the packets that I filed with the clerk's office, they haven't been showing up on the court docket. So what I'd like to do is preserve the record and just submit the packet so that the court has.
Okay, we're not that far yet. We're still doing our conference part.
Okay.
All right, so opening statements. Just as a general rule, Mr. Reefers, you need to stay within arm's reach of the podium. So the podium swivels, so you can turn it a little bit if you want to. Generally, it'll already be positioned. You have an HDMI plug-in at your table, which means that if you want to use any visual aids, any of that sort of stuff, if you want to play the videos, you can plug your computer into the system and it will play on the big screen to your right. You might want to make an appointment with Ms. Karoko to test that in advance of that. We also have an Elmo which pulls out from the podium. Anything that you put on that Elmo will go up on the screen. So if you have a photograph, for example, then that photograph would go up on the screen for the jury. Keep in mind, if you're going to show them text or anything, they are twice as far away from that document as you are. So what will frequently happen is, oh, look at Exhibit 2, and the jury all squints and looks like this because they can't see it, because you are twice as close to it as they are. If during a video you want it paused, you can pause it. You can you can have the witness draw on their terminal if you want. It's kind of like the John Madden Telestrator kind of thing. They can draw, they can point out things on that. Is there anything, there's not anything that's going to be particularly controversial that we need to make a ruling publishing to the jury in advance, right?
No. Not that I'm anticipating.
Right, Mr. Reefers? I mean, everything's pretty self-explanatory.
Yes, Your Honor.
The evidence? Okay. All right. So then we will, after openings, then usually it takes us the better part of the morning to do jury selection. We get to openings. We may start with the first witness before we break for lunch that first day. Sort of just depends on how things go. Ms. Idle is supposed to keep that day pretty light for us. So hopefully we're not going to have anything else on the docket for that day. We'll break for lunch, come back. We're going to finish in 2 days, right?
We should, yes, sure.
So state goes, I'm going to give the jury some instruction on how you are acting as your own lawyer. So I'll talk to them a little bit about that. But I'm going to give them a more detailed instruction if in fact you testify in the case. Then I will give them a separate instruction on sometimes you're talking as a lawyer, sometimes you're talking as a witness, and they are to only take evidence as what you're taking as a witness. Sometimes, Mr. Reefers, it's in your nature, not just you, but everybody who represents themselves, to try to inject facts into the case, sort of like an aside when you're questioning a witness, such as, well, that's not really what happened. What really happened was this, or it wasn't at 8 o'clock, it was actually at 9 o'clock. The only way that you can present evidence is by way of questioning through another witness. So ask questions, but don't make statements, because if you make statements, then I'm going to strike those from the record upon the request of the prosecutor. After that, we'll do closing arguments. Half hour, 45 minutes to closing arguments. Ms. Hyatt will do her initial closing, then you do your closing, and then she will finish. Jury instructions. Thereafter, they'll deliberate and reach a verdict. I generally will be able to, actually, I think I already have a draft of the instruction, so you probably will get a draft of the jury instructions the first day of the trial, and then we will talk about the jury instructions on the second day of trial. Is there anything else we need to talk about regarding procedure?
Not regarding procedure, Your Honor, no.
Mr. Reefers, anything else regarding procedure for the trial?
No, Your Honor.
Okay. Do you anticipate that you are going to have any witnesses other than perhaps yourself?
I couldn't tell you right now. I don't know.
Okay. Ms. Hyatt, do we have a witness list?
I do, Your Honor.
Okay. Did you already give that to me? I don't remember.
I don't know if I
have that or
did,
not.
Your Honor, but I can make.
Okay, if you could go ahead and email that to both myself and to Mr. Reefers
Okay.
after this. What I like is a witness list and an exhibit list. So all of the people that you're going to call as a witness, I want a list of them. Make sure that your witnesses are here, ready to go. The second time you run out of witnesses, you rest. That doesn't just apply to you, Mr. Reefers. That applies to every single person who walks into the courtroom. So first time it happens, so-and-so is supposed to be here, they're not. Okay, let's take a break. Let's rearrange some stuff. Second times it happens, your case is done. So you go with the witnesses that you have, make sure that they are all subpoenaed to be here early and that they're ready to go. All right, I think that covers everything from the court conference aspect of things. There's been no significant plea discussions, right?
Well, no, I mean, he was technically ILC eligible on the felonies. The only thing that would not have been ILC was the OVI. But that's where we kind of started with this whole thing, and that he did not want to do ILC at that point. So there really hasn't been much beyond that.
So at this point, there is no offer extended by the state.
Well, I mean, it would be to plead to the, hold on, I have to go back to that screen. Where was I? Goes way back, okay. And I'm sorry, while I'm looking for that, I'd also like to make a record that he has received the flash drive and that he has checked it out. It is operable. He can
Okay, we're not
hear.
that far. Let's take this one
Okay,
bite at
sorry.
a time or we're never going to get it all off our
I
plate.
get that. I'm sorry. Wait a minute. Sorry, just do it this way. It would be a plea to the improper handling with the forfeiture of the firearms and resisting arrest. I'm sorry, and the OVI. And we would dismiss then obstructing and resisting.
Okay, with no joint and recommended sentence or no opinion on sentence from the
I don't think I
state.
want to do an agreement on sentencing at this point without getting a little bit more information from Sergeant Simpson.
Okay, do you understand that offer, Mr. Reefers?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
All right, so, all right, one other, McClellan is going to come and testify live now, right?
He is, Your Honor.
Mr. Reefers, you had indicated to me that you needed Deputy McClellan's video deposition. Did you get that?
Yes, Your Honor. I was able to get that. She had provided a CD, I guess.
Okay, all right.
And for clarity, Your Honor, when we're emailing back and forth, I've been responding to the entry chain to try to keep everything preserved. There's been a lot of times that people keep jumping off chains. So for the record, what chain can we stay on to keep everything in one place?
Well, normally, Mr. Reefers, I don't want to be a part of your discovery discussions at all. And normally I am not part of that. If you want to make all of that part of the record at some point, just keep track of everything, all of the things that you get. You seem to do a pretty good job putting attachments together to your motions and stuff. Just make it a notice of email and then just attach it right to it. If that's what you want to do, that's fine. But in terms of putting everybody on one email and making them all be on that same chain, it's not practical, and we generally don't do it in criminal cases.
Thank you.
All right. So now let's talk about the motions that have been filed. First of all, we have the motion for a hearing on the
Your Honor, I'm
background
so
of.
sorry. I had one more question on discovery. I don't have any, I mean, I have all of his motions, but I don't have any actual documents or exhibits or anything that you're planning on using. So I'm assuming, as we're sitting here today, you don't have anything additional than what I've given you. Is that fair to say for discovery?
Your Honor, before we proceed again, I'd like to.
I just wanted to know.
Okay, well, let's go ahead and go into the motion
Okay,
part
that's
of
fine.
this. So, Ms. Reefers, you have stuff that you want to attach and make part of the record for today,
Yes, Your Honor.
and we're going to follow the same procedure. You're going to give me a packet, and I'm going to attach the packet to my entry, right?
Yes, Your Honor.
Okay, does Ms. Hyatt have a copy of this?
Yes, Your Honor. I've got everything here. If I can, I'll present present it now?
Okay, just give a copy to Ms. Kuroko.
Yes, Your Honor. So what this is this first packet here is broken into 4 parts, so we can keep track of everything. I've listed out in section 1 every motion that has been filed before the courts, and then 2 is the full compilation of every motion that I've filed here. Exhibit A is also then my peace officer license and continuing education, showing that my license is active until August 31st of 2025. And then Exhibit B is the contemporaneous notes that the deputy signed during the jail intake chemical test refusal back in November of 24. Those are attached as Exhibits A and B at the back. I've already given in that packet the section 2. The prosecution has already received that copy. So she's not getting that copy now because she's already received it and acknowledged every one of those receipts.
Just have your peace officer and items in it and the affidavit. I don't remember seeing your peace officer license.
All right, so we're going to attach this to today's entry. Actually, what I might do, if nobody has an issue with it, I'm going to do a separate notice of filing so that it is a separate document that is not my entry. And the reason that I would do that is because I think that we might have a little bit of issue uploading such a big document. So I want to make sure that it doesn't get attached to an entry. So our technical person, Ms. Kuroko, is going to solve that problem, but I'm going to figure out a way to make that so that this will just go, it will be in the record, but it won't be attached to my entry.
So is that still on the docket then?
Yes, it will appear on the docket as a notice of filing of, let's call this Defense Exhibit 8/27/25. So there'll be notice of filing of Defendant's Exhibit 8/27.25, and that will be filed.
Thank you.
All right, so with regard to your motions that were filed, it looks like a few days ago, maybe last week, motion for a hearing on the background discovery omissions. Do you want to present evidence on this hearing? Are we ready to go?
Yes, Your Honor.
Okay, go ahead.
I prepared for evidentiary hearing. I've got them all kind of submitted for yes/no format, just factual, straightforward,
Okay,
if I may. Who's the records custodian for administrative log investigation for discipline logs?
do you have a witness that you're calling, Mr. Reefers?
I'm just asking the state. They're the ones that are bringing everything forward. I'm asking for clarity on these options. and these
Okay.
questions.
Do we know the answer to his question, Ms. Hyatt?
Or, I'm sorry, which, we're on the Brady Giglio motion, is that correct?
The motion for a hearing on background of discovery and omission.
Missions of Brady, okay. And he's wanting, I'm sorry, he wants to know who the,
It's simple, just give a copy of the questions so you can follow along.
Sure.
okay. Okay, well. Well, the records custodian is the person that you were emailing, which was Paul Sarver. And that we have like a lot of emails between you and him.
And what software systems hold these logs? Is it Guardian, iPro, Power DMS?
I have no idea.
And what is the definition of the administration investigation logs versus discipline logs?
I mean, I don't know. I mean, you're asking the wrong person on this stuff. But this is stuff I thought you and Paul Sarver had already talked about. Because he indicated, he gave you the discipline logs that they had he gave you the policies that they had, that you requested, or he tried to at least meet with what you were requesting with, and match that with whatever seemed to be the policy pertaining to that. But that's all in those emails that you and he were exchanging.
Okay, but we're still missing, there was 6 years of logs that are missing, and then there's logs that are entered in the administrative log that are not on the investigation log. There's still outstanding disciplines.
What outstanding disciplines are you looking for?
There was one from July of 23, I believe, that wasn't listed for conduct unbecoming for Deputy Simpson.
That was, okay. I guess I'm trying to figure out what you are calling disciplinary log versus administrative log. I don't know
What I'm referring
how
to
you're
is that,
determining them, so.
yes, what I'm referring to is the email where you'd sent and responded back in July, said that you was ready for trial, that you'd done the Brady Giglio search, that no relevance with these deputies. And then at 4:45, when Paul jumped out of the email chain and sent it separately, he sent the administrative log, the investigative logs. The
Right.
administration log, investigation log, there were 6 years that are missing, that there's just no information for it. I still don't have the full, complete disciplinaries for each of those findings.
So under the administrative investigations log, you're talking about where it said Jack Simpson / Rob Henry unbecoming conduct remedial training. Is that what you're talking about?
Correct.
Okay. Because that was the only one that I think pertained to Sergeant Simpson out of those administrative investigation logs. All right, but, okay, and I guess my question is I have to turn over exculpatory evidence and evidence that would change, like would be helpful for you, harmful for me, or regardless, I have to turn all that over. But stuff where they're late for shift or they didn't report for something, that doesn't go to their character for truthfulness. And so this conduct unbecoming, if you want to ask Sergeant Simpson about that, it's because he reported a fellow officer for sexual harassment. And they had an issue with the way he reported
One at
it.
a time, please.
And they had an issue with the way he reported it. And he can explain that, but that doesn't go to his truthfulness of character. And that's what that's the stuff I have to turn over, is things that you can challenge him. You know, if he was a liar or he stole or something of that nature is what I have to turn over under the Brady.
Okay. So the unbecoming conduct, the failed to renew and toxilizer certification, the evidence mishandling, those write-ups are not Brady Giglio related. It goes to his truthfulness and worthiness of what he's telling us.
No, it actually doesn't, because it goes to, you have the cruiser cam of the incident. So you have his report. I mean, you can question anything that is inconsistencies. You're more than welcome to do that, but.
Continuing on, I guess. What is the retention schedule for these logs?
Wrong person. I mean, all of them. I mean, I'll tell you right now,
Okay, do
anything
administrative,
going through all of these, I don't have answers for this.
and Your Honor, this is the issue. If the state can't answer these questions, then why are we here?
Because
We're here today for an evidentiary hearing on your motion, Mr. Reefers, and I think what Ms. Hyatt has just represented to the court is that she has looked through the 148 question, well, really 141, but we have the relief and remedy part that I've omitted. That she does not know the answer to the questions that are contained in your outline. Is that correctly stated, Ms. Hyatt?
At least, yes, at least for the ones that I haven't had a chance to even go through.
All right, go ahead, Mr. Reefers. Anything else?
Yes, Your Honor. Do administrative investigation logs exist for 2015, 2018 through 2022?
I think she already said that she doesn't have the information She doesn't have the answers for the rest of these questions. There's no point in going through all of them individually. If she doesn't have the answers, we might as well take them as a group and just accept that her answer for each of these is going to be, I don't know, I'm not the right person to ask. Right, Ms. Hyatt?
Correct.
All right, continue, Mr. Reefers.
Okay. Has the state requested a full export from each system, including inactive or closed cases?
Again, same answer. I'm going through this. The same answer is going to be through. I'm not sure what you mean, like under 11, policy titles and version dates. I've given you the body, I've given you the cruiser cam, video and audio now that I have. There are no body cams because they didn't have body cams until this year. Let's see. Going through, that's all I have through that B. Under C, did Deputy Simpson have a body mic assigned that night? We know he did. It was malfunctioning. And 29, does any body mic audio exist for this stop? And we've already explained, there is no body mic. It was malfunctioning that night. So you have what I have. I cannot manufacture body mic audio after the fact. So does any in-car audio exist? You have that. That was the thing that you said because you couldn't hear what happened outside. That has now been produced. You have had that. Let's see. That's all I have for C.
Hang on here.
Under D, let's
Ma'am.
see. Yes.
Next question. Does policy require deputies to collect and preserve all available evidence, including exculpatory evidence?
I don't know which question you
Question
want.
15.
I would imagine that would be true. They have to collect all the evidence.
And why didn't Deputy Simpson collect the sample that I have been requesting? That's the
doesn't-
whole premise of this. That night, I'm still missing the video clip, the 90 minutes from the jail, when I made such a huge deal about why Deputy Roberts called Deputy Simpson. I was adamant, requesting tests, come back, do your job, give me the test. This is what you're required to do.
They did.
Deputy Roberts called Deputy Simpson.
How do you
Deputy
know
Simpson-
that?
Because I just submitted Exhibit B that when I made such a big deal at the jail, that I told the 3 deputies sitting there, you 3, please write down your names on a piece of paper so that when this goes to court, that he deprived me of my rights, you guys will come in and testify that you did this.
And where
And it takes
is
also-
that? Where is
It's
that?
Evidence, Exhibit B.
That's just somebody's handwriting, writing their names down.
Exactly. That's the
That's not
video.
theirs. And it doesn't have
Yes, ma'am.
anything to say why they wrote their name down there.
Exactly. That's where the video comes in. And here's the original piece that they wrote down the day it was booked in. That's what that copy is.
Okay,
Because I made-
we're getting a little off track here because this is turning into an argument, not an evidentiary hearing.
Your Honor, I'm
Mr.
just
Reefers,
asking
do
for-
you have any additional evidence to present on this point?
I
Ms.
would-
Hyatt has already said that she does not know the answer to your questions. You need to move on from your questions and present additional evidence if you have it.
Okay. Does policy require deputies to honor a subject's request for chemical testing in an OVI arrest?
Mr. Reefers, we're done asking questions of Ms. Hyatt on this point. She has said that she doesn't know the answer to your questions.
Your Honor, if the prosecutor admits she can't answer these questions today, then this is exactly the prejudice I've been raising. These are yes/no questions about discovery, chain of custody, witness credibility. If the state cannot answer, then the record is incomplete. My rights are violated, and only the proper time to remedy that prejudice is now, not later. I'm entitled under Brady Giglio Rule 16 and due process to this information. The state either has it or it does not. If it does, it should be answered. If it does not, then I respectfully move for dismissal or suppression of the record today.
All right, anything else you want to tell me on that issue?
I would like to continue asking my questions.
Again, Mr. Reefers, I'm trying to make accommodations for you because you're representing yourself in this case. The correct way to present evidence in a hearing is not to ask the lawyer on the other side the questions that you have. if you had evidence that you wanted to present today, you should have subpoenaed a witness for today, somebody like Mr. Sarver who might have the answers to these questions. You might be presenting some documentary evidence about what's contained in your communications with Mr. Sarver, which indicates that maybe we have or maybe we don't have those things. But it is not proper to just ask the prosecuting attorney a bunch of questions about what records are kept by the sheriff's department. It is proper to ask her what she's turned over and what she has. And from what she's telling me, she has turned over all of the evidence that she has. And the court has already gone to the extraordinary step of making a thumb drive that has all of that evidence preserved on it, so that if it comes up during the trial, that there is something that you haven't seen or I haven't seen, or if it comes out later after the trial that there is something that was hidden, all of that has been properly preserved for the purposes of your motion.
Yes, Your Honor. So not to ask in those questions that she can't answer, but ones that she should be able to answer, as far as like while we're at the jail, that 90 minutes or so that's missing from the.
Do you know what happened to the 90 minutes or so that Mr. Reefer says is missing?
I don't know what all was required. I mean, I have the jail video about the interaction he had with Corrections Officer Roberts. And then after that, he's let off. So I'm not sure what 90 minutes he's talking about, but he does have the jail video of when he was booked in and when the altercation between him and Officer Roberts occurred. And
Okay.
then he was led away. I mean, he does have that.
All right. Anything else on this issue, Mr. Reefers?
Can I ask questions that she should be able to answer?
Go ahead.
Can you give me a number?
Yes, ma'am. What? Okay. Was videos checked for, it's question 39. Was videos checked for tampering, gaps, or errors?
I mean, before Mr. Sarver gave it to me, I mean, I got what you have. So if you're, I mean, I don't
That's
know.
what I'm
if
wanting
there's-
to- Did you
I
search
don't
for
know.
these things?
How would I search? I get a video. How do I mean, can you, I'm not technical. You tell me, how do I look at that video and see that it's been tampered with? It has gaps or errors in it. It's not just what it purports to be.
And that's, I guess we're at,
I give
The
you what
issue
I
is-
received from Mr. Sarver.
One at a time, please.
Sorry.
so who made the 14-minute clip then?
My office did. Okay, this
This is-
14-minute clip that actually Mr. Sarver did on our behalf, because that's how we were able to get the audio with the video for Officer McClellan. Okay, for Deputy McClellan's, it is the first 14 minutes of the whole Deputy McClellan cruiser cam that you have. I'm required, if I can, to clip it because that's the only part I was planning on showing to the jury. So you have that 14-minute clip because it's part of the whole cruiser cam that you've received. And on that flash drive, you now have the audio along with him outside of the cruiser. So that whole 14 minutes that has him pulling in, getting out, interacting with you, and you can now hear it outside of what they're saying outside the cruiser. You have that on the flash drive. It is the whole cruiser cam. I've clipped it because that's the part I'm proposing to play for the jury, and the judge prefers us to clip it if we can. So you have that video, you just don't have it as a 14-minute clip. You have the whole cruiser cam with all the audio on it. It's not a separate clip. It's not a separate video that you don't have.
Is that the way the court prefers it, Your Honor?
I don't have a preference on the manner in which everybody presents their
Thank you.
evidence.
All right, moving on. 41, was a crash report or diagram completed?
Ms. Reefers, this is the last time I'm going to say this. It is not proper for you to ask Ms. Hyatt questions about how other people keep their records and maintain their records. You can ask her about things that she may have received and that she did or did not turn over. But if if we're going to keep asking questions about what other agencies do, then this part of your examination and your questioning is going to come to an end.
I'm asking if the state did a crash report. The deputies were there. They did a crash report. I'm asking if she had completed one and it had been presented.
You have the crash report that I have that was generated as a result of
Is it-
you backing up and leaving that property.
Thank you. Is the crash report accurate?
You have the crash report I received.
So
Is it
that's no.
accurate?
No.
Well, then you need,
We're
but you're
photograph-
not charged with hitting that car, but that's another reason why we're not here, but
All right, we're moving on from this. Next is we have notice of preservation of records. I will go ahead and make your question. We'll call this defense, defendant exhibit 8, 2725-2. And the big packet will be 82725-1. All right, anything on the notice of preservation of records? Mr. Reefers?
Yes, Your Honor, I got the packet in so I could preserve the record and all the files.
Okay. Motion to recall Ashley Burns. Is there anything additional you want to tell me about your request to recall Ashley Burns?
No, Your Honor, just be able to confront her in open court if it were to go to trial setting. We keep talking about trial setting, but there's still threshold matters that hadn't been resolved before we go further.
Okay. Anything additional on your motion to compel video jail evidence?
No, Your Honor, I'm still requesting the missing videos and clips that haven't been provided.
All right. Anything else on the supplemental notice of discovery gaps?
Still requesting the outstanding disciplines, the full transcripts and the logs that are actually go along with the disciplines. There's a full file that I've received separately, independently, that has the full file of every discipline that happened.
All right. Anything else from the defense, Mr. Reefers?
Does the state know if Deputy Simpson's intoxilizer certification is current?
Yeah, we're not going through all of that stuff, Mr. Reefers. We've already concluded that portion of the hearing. If you wanted to know those things, you should have subpoenaed the deputy to be here at this hearing today. Ms. Hyatt, anything additional from the state?
Your Honor, just a couple of, first of all, I want to confirm that other than what I just received now, which I'm assuming is his certificate, and I don't know what exactly this Exhibit B is, but I have received Exhibit B. I have no other actual documentation that would be a possible exhibit at trial. I just want to confirm that that is correct from Mr. Reefers. Is that correct?
I'm sorry.
Do you have any other exhibits that you're planning on using at trial other than what I've already given you, and besides this Exhibit B in your law certificate, enforcement certificate?
I've submitted everything.
Okay, so those are the only documents then, because this is in addition to motions. Okay. The other thing is I want to put on the record that he has received the flash drive from our office with the cruiser cams on it, that he was shown when he came to the office how to toggle between the two audios, so he can now hear when the deputy, like Deputy Eastham, Deputy McClellan, when they exit the cruiser, you can toggle to the other audio and he can now hear outside of those cruisers. Those are for examples that are on there. And that we don't have a corruption of cruiser cams or that kind of argument again, that I can't hear this or I've never been able to hear this the morning of trial. I just want to confirm that with you on the record. Have you had a chance to look at the flash drive?
Yes, ma'am.
Okay, and you've played them?
Yes, ma'am.
Okay, and can you hear, do you agree, you can now hear the audio on Deputy McClellan, Deputy Eastham? I want to say Deputy Peters is the one that there was nothing outside. I think there was one.
And then, so is it Lieutenant Cato now, where his cuts out at 8-9 minutes in?
His did cut out, but that is what we have. And you can now hear that, what's there. Okay, so on the record, that flash drive you now have the audio and video that's available.
Correct.
Okay, thank you. That's what I just want to make sure.
Okay. All right, I will take these matters under advisement. I will issue a written decision. We'll see everybody here at 8:15 for the trial.
Your Honor, if I may.
Sure?
Your Honor, this case has been about one simple truth. I requested a chemical test that night, and the state refused to provide it. That denial, along with the missing reports and incomplete evidence, cuts to the heart of due process. No jury can fairly weigh what was never preserved. For the record, I've submitted every filing and every question before you. I stand ready to answer, but I respectfully state the evidence is incomplete, the prejudice is clear, and dismissal is the only just remedy.
All right, we'll see everybody back here for trial.
Thank you.
Let's quickly go ahead and scan those.
So they'll know if you're going toward a residence or place of employment, and they're going to know the other too, whether or not you're just going somewhere else in our, incidentally or coincidentally, I should say, in the realm of the 2 miles while driving in the course of the employment, okay?
Okay.
All right, I wish you well. Any other questions?
No.
Detective, anything else?
No, Your Honor, thank you.
Thank you very much. All right,
Thank you.
thanks. So you'll get on with them. Thank you.
Yes, I will.
Paul Joshua Tyson, 250-720-272. Okay, your name again?
Detective Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, 8:25 of 25 at approximately 10:30 in the evening, officers Frierson and Harshbarger with the Rockwood Police Department was dispatched to the Rebel gas station, 22855 Hanover Drive in the city of Rockwood in reference to a VIN verification. Upon the officers' arrival, they spoke with Todd Taylor. Taylor stated he spoke with the subject by the name of Timothy on Facebook Marketplace, who was currently selling a white 2009 GMC 350 heavy-duty pickup truck with a VIN number of 1 G George, T Tom, J John, K King, 83699 F Frank, 136375. Mr. Taylor stated that he was purchasing the vehicle for $9,500. However, when he looked on Kelly Blue Book, the value of the pickup truck was over $19,000. He thought it was suspicious in nature and requested that the officers do a VIN verification due to the suspicious nature and the sale price of the vehicle. The officers ran the VIN through Lean SOS, and the vehicle currently came back as a stolen vehicle out of Old Bridge Township, New Jersey. Shortly thereafter, the vehicle pulled into the parking lot of the Rebel gas station, and the driver was identified as Paul Tyson. Officers confirmed the VIN number that was attached to the vehicle, as well as Mr. Tyson had the title to the vehicle as well. When Mr. Tyson stated that he was selling the vehicle for a family member, when officers asked what was the family member's name, he refused to answer at that point and requested an attorney. A lien check confirmed that the vehicle was stolen out of Old Bridge Township, New Jersey. And when I spoke with the detective in Old Bridge, she stated it was a Sale went bad there where it was used a fraudulent check to purchase the vehicle. That's why it was reported stolen. I also did a value of the vehicle check through Kelly Blue Book myself for the value of the truck by VIN number, and it showed that the value of a private sale is $19,855. I submitted a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
Do you have these prior convictions here, February 8 of 11 for robbery armed and felony firearm, and also September 22 of 22, retail fraud first?
Yes, Your Honor.
Based on your sworn testimony, I find the crime of receiving and concealing motor vehicle was committed. There's probable cause to believe the crime was committed by the defendant and that the defendant has the prior convictions giving rise to the habitual fourth offense notice. So I'm authorizing, I'll note you signed, I'm signing and dating the complaint and the warrant for the arrest of the defendant. All right, so Mr. Tyson, your name, sir?
Paul Tyson.
Okay.
Sure, thanks, Paul Tyson, legal aid former reading stand.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. Again, if you cannot afford one, I will appoint you one at public expense. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. That will take place September the 9th at 8:45. Preliminary exam, September the 16th at 10:30. Those will be in front of me. And I want you to understand, if you're convicted of a 5-year felony, which RNC motor vehicle is, since you have allegedly the 3 prior felony convictions, you could get life. Do you understand that?
Yes.
All right. So September 9th, 8:45, September 16th, 10:30. You can go ahead and address bond.
Thank you, Your Honor. With regard to those priors, Mr. Tyson tells me that he served 10 years on the 2011 matter, and then successfully completed parole. And he's currently on probation to Oakland County on the 2022 matter. He said he was set to be released from probation September 22nd, so it's coming up shortly. He indicated he's had some health issues. He had a major surgery in December. Has been unable to work since then. He is requesting court-appointed attorney going forward. And with regard to the bond, he indicates he really has very little money, and anything over 2,010%, he probably is going to be in custody until the next court date.
Lieutenant, what do you have to say? Does he have any holds, any other convictions?
Your Honor, he's got a few traffic warrants. Other than that, just what we already stated in court, but I'll leave it to the court's discretion.
You said he's got some traffic warrants?
I believe so, Your Honor.
I'm sorry?
Yes, Your Honor, he's got 3.5 pages of them.
Yeah, you got 8 warrants, 9 warrants. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with Robert Ida or Todd Taylor. No contact with either one of those individuals. Also, no contact with prosecution witnesses. 20,000, 10%. You got to show up in court, sir. You can't have multiple warrants and expect a personal bond. 20,000, 10%. You're going to have to post $2,000 to secure your release. September 9th, you'll be back in front of me. Any questions? Any questions?
Yeah. You said 20,000?
20,000, 10%. Yes, sir. You got to show up in court.
I show up, I always show
You got
up.
8 warrants. No, you don't. You got 8 warrants. Come on. Don't argue with me.
Okay,
You got 8, I think 9 warrants, actually. Good luck to you. You got to show up. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
David Maurice Ford, 25W8367708. Jennifer, did Mr. Gallup send that over?
Judge, I just got the email from his secretary and I'm waiting for the system to scan it. So
Okay.
it's just going to take a second.
As soon as you get it, give Ms.
I'll
Mount,
be right down.
or she can get a copy, I'll get a copy. Your name, sir?
David Maurice Ford.
All right, so you have failure to appear for weekly testing on August 12th. Failure to refrain from consuming alcohol or drugs. Positive results for THC on August 13. Lab confirmed the positive results on the THC. Failed to refrain from consuming alcohol or drugs, testing positive for THC on August 17. And then failed to refrain from consuming alcohol or drugs, testing positive on August 23. And by the way, the lab confirmed the positive results of the THC on August 17. So you have 4 charges here. If you plead guilty, if you're found guilty of those, you'd have more than 4 more technical violations and your probation could be revoked. And you could be incarcerated for the maximum provided by law, which in this case is, give me 1 second, please. Which is 93 days. Do you understand that?
Yes, sir.
And you're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses. You have the right to use the subpoena powers of the court to bring in your own witnesses, to testify or remain silent. If you plead guilty, you're giving up all those rights, and we're not going to have a contested hearing of any kind. Do you understand that?
Yes, sir.
Now, again, you have the right to an attorney. If you want a lawyer, I'll be happy to give you one today at public expense. If you want me to adjourn it so you can retain your own, Mr. Zelnick or whoever else, I'll be glad to do that. It's entirely up to you.
I would like Mr. Zelnick to represent me, please.
Okay? I'm going to a not guilty plea for you.
Yes, sir.
I'm going to please, I'm going to ask you for a date. Do you know when Mr. Zelnick's coming back?
No, sir.
Do you know where he went?
France.
Yeah, okay. I think if we go out a week, that should be good. What do you-
September 4th at 9 o'clock.
If he's not going to be back by then, we'll just adjourn it again, Lisa. So if he's not back and they call, or Mr. Zelnick or his office calls, I'll be glad to reschedule that. So I'm going to give you a $500 personal bond. You must comply with all terms and conditions of probation. And you must appear in court as directed. And we're going to set this again for September 4th at 9 o'clock. You'll get a notice down the hall. Do you have any questions for me?
No, sir.
All right, see you back here then. Thank you. Good luck.
Have a great day. Thank you.
Thank you, you too.
That's the order, and I just want to show, this is what I typed up to attach to their notice, so that you can see.
Hang on, don't go anywhere.
Mel's got a copy as well.
Ms. Mount, when you're done looking at this, you tell my court officer and then I'll recall the case, okay? Take your time.
I did read.
You read the whole thing?
Yeah.
Okay. Where's that
I
from?
think it got brought back down to me, Judge. I'll go get it.
Okay.
But you can go back.
Krieger, Haley Krieger, Haley Jean Krieger, 23B144245. Good morning.
Ready?
Your name?
Haley Krieger.
So you're charged with failure to refrain from consuming alcohol, testing positive on August 25th. You admittedly drank. This says you have prior technical violations. Your probation could be revoked and you could be incarcerated for the maximum provided by law, which is up to 93 days. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers to court, to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
All right, you have the right to an attorney. I'll be happy to give you money at public expense. Would you like a lawyer?
No, thank you.
You waive your right to a lawyer?
Yes.
Call in Emily. To the charge that you failed to refrain from consuming alcohol, testing positive at a chemical test on August 25th, how do you plead?
Guilty.
Did you drink alcohol, say, within the 3 days preceding this?
No.
No, listen to my question.
Sorry.
Did you consume alcohol within the 3 days before August the 25th? What did you drink?
I had a Bloody Mary.
Where?
I was at brunch with a friend.
At where?
Public House. It's a restaurant. I
Would
was
they,
at brunch with a friend.
anybody force you to plead guilty?
No.
All right. All right, I'm gonna accept your plea. I'm gonna get in here. Really? What are you doing? Come on, talk. You're ready to graduate. Right?
Yeah. It's not a reality or anything. I'm the one in charge. I just messed up.
Your name?
Alexia.
Can I please see the letter you were referencing? Haley, why?
I know. It was careless on my part.
So this is the third or second time she's drank?
Would be the second, I believe her last one was 4th of July, 2024.
Where'd you go?
This
Yeah.
one, I was at a restaurant. It's called Public House.
Where's that at?
In Durham.
I placed her on probation, I believe, on November 29th of 23.
So if we kept her to the end, she would have, what, 94 days?
What do you think?
You know, I do give her a lot of credit for being honest. You know, I don't know, she didn't send it to the lab, but if it was one, you know, she could have got away with it potentially. You know, she was honest the last time too. You know, I genuinely think she's trying. You know, she is probably someone that it's not ideal, but that I would advocate to keep to the end. I would like to probably get her back into treatment. She has already completed, and, you know.
Relapse prevention, right?
You went to Guidance Center, right? Yeah, they would, they do have the relapse prevention group. And she is phase 4, so she's once a week testing, so, you know, probably some, at least yellow for the time being.
Oh, boy. Haley, I've been so proud of you.
I know. I'm disappointed in myself as well.
So you wanted to test twice per week, right?
Correct.
So when am I gonna graduate her though?
What, I don't even know what day that falls on.
29th is a Monday. The 25th is probably Thanksgiving.
Well, we're off Thursday, Friday, and then status review, probably that Tuesday or Wednesday. Okay. So it would still be 90, we have 4 kind of days, she would still graduate with 90, even if it was that Tuesday, right?
Anything else you want to say before I sentence you?
It won't happen again, and I really apologize.
Pay costs in this case in the amount of $75. Serve 2 days on the court work program and pay $70 for those days. You're to attend a relapse prevention program. You're to test twice per week until the end of probation. You owe $145. I'm going to give you until, I don't know when you can pay it. I'm just going to say September the 12th for you to pay those costs. I'll let you guys worry about what day we're going to do it. I don't know what day we can do it.
I'll figure it out.
First is,
I haven't figured out your dates that far.
I got it. Haley. No more. Come on. Too close now, and we're not gonna be able to, you're not gonna have us looking over your shoulder. I know, but I'm talking about when you're done with the program. You're right here. You've done fantastic. I mean, you go back to that life and
I don't want to, I've changed a lot.
I know you have. You're a great kid. I think the world of you. No more. Come on. All right? Good luck. Thanks.
Thank you.
All right, Joshua Schaefer. Joshua Edward Schaefer, 258-149-261A and B. Folks, I'm sorry it's taken so long here this morning. I really am. Your name, sir?
Joshua Schaefer.
Drywall suspend, August 7/25 incident. You have the right to a lawyer. Do you want one?
No, sir.
It is alleged that on August 7/25 that you did operate a motor vehicle on Telegraph near Stroon in Brownstown at 10:28 p.m. with a suspended license, a misdemeanor punishable by up to 500 fines, 93 days jail, costs for all those 2 points. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
Excuse me. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You have the right to a lawyer, and you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. I'm giving you a $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm entering a plea of denial on the no proof of insurance. My court officer is going to take this file to the Brownstown Township Attorney. They will meet with you soon. Any questions?
You'll meet today?
Yeah.
Oh,
And then either way, you're coming back in front of me.
And he will be eligible for judicial release after 18 months. Is that accurately stated?
Yes, Your Honor.
Yes, Your Honor.
Mr. Taylor, how old are you?
43.
How far did you go in school?
63, I'm sorry.
Okay,
I graduated.
43, 63, that's a big difference.
63, I'm sorry.
All right, that's okay. How far did you go in school?
Graduated.
Are you able to read and write English?
Yeah.
Are you under the influence of drugs or alcohol?
No,
Are you taking any medications?
no.
We've had some discussions about your case. Other than what we've talked about today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Kirby before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
Going to be entering a plea of guilty to 1 count of aggravated trafficking in drugs, third-degree felony, punishable by 36 months in prison and a $10,000 fine. Also carries with it a forfeiture specification for the money, and it also carries with it a mandatory fine in the amount of $5,000. And the sentence also carries an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge and this specification, you're going to give up all of those rights. You're going to admit that you did it. We're going to get on to the 36-month prison sentence. Is that what you want to do?
Yeah.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on May the 12th of 2025 in the city of Franklin, Warren County, state of Ohio, the Franklin Police Department executed a search warrant on the defendant's residence, and during a search of the defendant's room located within, with his identification, was a total of 21 grams of what was later tested to be methamphetamine, as well as other indications of trafficking and $2,000 in U.S. currency that was seized from a safe.
Anything on those facts, Mr. Kirby?
No, Judge.
Mr. Taylor, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence?
No, Your Honor.
I think we're prepared to go forward today.
Do we have a jail time credit figure?
I have it 19 days, Judge.
All right. Anything additional from the state?
No, Your Honor.
We do have the affidavit of indigency executed by Mr. Taylor. Anything else, Mr. Kirby?
Judge, this is Terry's second prison number. The first one was about 3 decades ago. He's been in active addiction over the years. It's strained his relationships. He lost a brother to a drug-related issue. Your Honor, he understands that his sobriety is paramount, especially at his age and with his poor health. And he is going to take advantage of the resources in the prison. Judge, we'd ask the court to adopt the joint recommended sentence. That's all.
Anything you want to tell me, Mr. Taylor?
No, sir.
I am going to sentence you to 36 months in prison. This includes an optional period of post-release control. That means if you serve the entire sentence, the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the sentence that you will receive for the new felony. I find that you're indigent for the purposes of fines and costs, so there will be no financial sanction, and we have 19 days of jail time credit. Anything else we need to do? Anything I forgot?
No, Your Honor.
No, Your Honor.
All right, finally, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you, Mr. Taylor. All right, we ready for PVs?
Friends, do you want me to call for PVs or do you want?
Okay?
Yes.
This one goes to, I don't know. Lisa, am I having Krieger taken down to you or to probation?
Probation.
Good. Yeah, take that one to probation, Krieger. JTT Jefferson LLC, 25B 82610. Mr. Blanchard, where are you, please?
Mrs. Blanchard?
Oh, I'm sorry. My mistake. I just saw Blanchard on there. How are you?
I'm good. How are you, Judge Madonna Blanchard, on behalf of JT?
My apologies, sincere. Your name, sir?
Timothy Shamus.
All right, so they're moving to dismiss, right? Case dismissed. You did.
That's correct.
All right, have a great day. Sorry to keep you waiting so long.
Thank you.
TNT Contracting, 25B1487766A and B. Your name, sir?
Thomas David.
It's TNT Contracting, that's a corporation. You gotta have you get a lawyer. Okay?
Yeah.
I can't, you have to have a lawyer on a misdemeanor. This is a misdemeanor. It's not my rule. We're gonna adjourn it one last time. You gotta get a lawyer though, okay?
Yeah, how long will be,
I'll give you a couple weeks. Lisa, give me a new date.
Weeks. Do you want 2 weeks, Judge?
Yeah, that's good, unless a week, whatever.
September 10th at 9 o'clock.
September 10th at 9 a.m., okay? And again, your name is David?
no, Thomas, first name.
Thomas David?
Yeah.
What? Oh, Thomas David. Okay, I'm sorry. You're the principal?
Yes.
Okay, good enough. I wish you well. I'm gonna go ahead and you go down the hall, get that notice, but again, you have to hire a lawyer, okay?
Okay.
Thank you.
Thank you.
Did you look at that? Are you good with that?
Yes, except for during the
I don't even have my copy now. Jeez. Jennifer,
You need me to print you another one, Judge?
I don't know what happened to it. Yeah, I need one.
Okay, I'll write down.
All right. Did I do something with that? All right. These are. Jesus. All right. You have a lawyer yet, Ms. Garrett?
Yeah.
Who's your lawyer?
Lady over there.
I spoke to her, Judge.
Oh, right there she is.
I don't know where the file is.
I brought him in, Judge.
I need this file.
I don't know who you're,
Garrett.
who'd you give it to, Theo?
You're free.
Oh, just, Deborah's got it.
Okay. I don't know what happened.
I don't know, do you have the notice up here as well or no?
Concord versus Amanda Mount, 2501975 LT.
Good morning, Your Honor. Creighton Gallopy, 63002 on behalf of the plaintiff.
Your name, ma'am?
Amanda Mount.
All right. Did you look at the order?
Yes, I did. Under page 2E, it just has the wrong address.
Oh,
Yeah.
replacing molding in the dining room at the floor underneath the dining room window on the wall that borders 22872. Where do you live?
70.
Oh, just a clerical error, Judge. Just a clerical one, Judge.
Yeah, so you're gonna change that.
Other than that, all is well.
Judge, if you want, do you want to just make a circle on the two? I can send it to you if you just want.
No, you know what? I just want you to, I'm gonna change that.
I can send to the change, Judge. You can take my initials. It's just it's a Scrivener's error.
Ms. Mount, you agree to all these
Yes,
terms?
yeah.
You do?
Yes.
You do, right, counsel?
Yes, Judge.
And I'm just gonna make a note, parties agree to order as presented. I did change that, okay?
Great. Thank you, Judge.
I haven't read through this, so I'm trusting that you looked at it real well and you know everything, right? This is all good with you?
Yes.
Good enough. Go down the hall, we'll give you a copy, we'll send it over. I'd encourage you two to keep talking if you can, okay?
Go to,
All the way down.
All the way down to the civil department.
okay, thank you.
All right. Do you have Garrett?
Thanks, Judge.
Thank you. I'm gonna need you to call in Emily. People against Amanda, Justine Garrett, 25T700567.
Deanne Patillo on behalf of Ms. Garrett, state your full name, please, for it.
Amanda Justine Garrett.
Ms. Patillo, I just want to make sure you know what's going on here.
Somewhat, Judge.
So I sentenced her initially.
Yes.
And that was back in May sometime, May the 20th. And then she came up with this probation violation and she went inpatient to her credit on her own in California. And at that point, I sensed that she needed some help and I said, why don't we convert this to a sobriety court case? She seemed amenable. That's where we are with this now. So I'm going to go ahead and put her in sobriety court. And I'm going to take into account, if you saw this one place here, let me just find it.
Are you talking about?
She paid all the fines except she still owes. She's still going to have to pay the $400 in probation fees. I'm sorry. Wait a minute. Let me just double check one thing. This is where it's going to get kind of complicated. I just want to make sure. So initially I placed her on probation on May the 20th for 12 months. So I need to add some more probation fees because we're going to make it 20 months, which will essentially make it 24 months. Okay?
$400?
It's a lot more than $400.
How much is it for another, I mean, I'm getting more probation. I know that, but like, so I have to pay to be in this program?
Oh, yeah. Now, listen, we're not a money-making outfit, but we have to. There's nothing I can do on
I mean,
that.
I paid, I think, what, 2,000 some, or 3,000
Let me double check.
on May?
Hang on one second. I initially ordered 1205.
Maybe that's what it was.
It's a far cry from 3,000.
Okay, but I haven't, it's been a while, but so I need.
Up to the podium, please. Mr. Hines, we're here today because I received a report that alleges you have violated the terms of your supervision. Officer Sukovecki, what are the allegations?
General Commission Rule number 7 on August 8th, 2025, the defendant submitted to a drug screen with a positive result for methamphetamine and device use. The sample was sent to the lab for confirmation of positive. On August 20th, 2025, the defendant submitted to a drug screen with positive results for methamphetamine and amphetamine and admitted to drugs.
What's the recommendation of probation, if anything?
The first recommendation is for him to successfully complete the PhD program with River Rocks Recovery and all recommended aftercare. Monitor with treatment and work release for at least 30 days. Random drug testing and comply with the password and complete the
Mr. Hines, you have the right to be represented by a lawyer in this case, and if you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer? Ms. Caruco has a. He does not wish to be represented by a lawyer. So she has a waiver that tells me you don't want to be represented by a lawyer.
Thank you.
I'm going to accept your waiver. Do you admit or do you deny that you violated the terms of your supervision? Based upon your admission, I find you have violated the terms of supervision. Mr. Harris, state a position in any of this?
Your Honor, I do note he has 32 days of jail time credit. We would defer to the recommendations of the probation department.
What do you want to tell me, Mr. Hines?
Your Honor, I have been coming in front of you for 10 years. I came in front of you for the first time at 19. My 29th birthday was 10 days ago. I am so done with this. For the first time in my life, I really feel like I have something that I can't afford to lose. I've built a family, got kids, a fiance. I'm so tired of being a drug addict and being in and out of court, in and out of jail. I just want to do better. I just want to be a provider for my family. I want to be a role model for my son. I want to be somebody my fiance can depend on. I'm so tired of living like this. So any kind of help I can get for drug recovery, I am more than willing to accept.
Officer West seems like she's got a good plan set for you, doing the PHP, River Rocks.
I don't exactly know what that means.
And he hasn't been accepted to that yet, right?
No, he still has to be assessed, and with River Rocks, they don't have any housing. It's, he was initially assessed with the coach for PHP without supportive housing, since he has a stable place to live, and River Rocks can provide that. He just has to be assessed with them first.
All right, so let's do this. Let's set this for a final hearing next week, and then we'll get the assessment done. I do want to continue you in treatment. I'm not ready to let you out of jail until that treatment plan is in place. So Officer West is going to come see you and talk to you about what the plan is. She's going to make the referrals so that you can go right from the jail back into the community and back into treatment.
I appreciate it.
All right, that's all. Next is the case of the state of Ohio versus Tyrone Allen. This is case number 24 CR 42183. Step up to the podium, Mr. Allen. We're here today, Mr. Allen, because I've received a report that alleges that you have violated the terms of your supervision. Officer Sukovecki, what are the allegations?
General conditions, number 1, on July 17th, 2025, the defendant was convicted of obstructing official business, misdemeanor 2, through Hamilton County Municipal Court. General conditions, number 5, on June 13th, 2025, the defendant cut his electronic monitor off. As a result, a warrant was issued. General conditions, rule number 7, on June 11th, 2025, and the 12th of 2025, the defendant failed to submit to a drug test as ordered.
Sir Allen, you have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint one for you. You want to be represented by a lawyer, right?
No.
Because, I mean, you have another case pending in front of us right now where you're represented by Mr. Elter, right?
Yes, for cutting off the box of felony.
So it makes sense to go ahead and appoint Mr. Elter in this case and set these together for a global resolution, doesn't it?
Yes, I thought maybe I could just get it over with today, if possible.
I mean, what does getting it over with in your world mean?
Just from the beginning, me getting put on probation, I got underlying issues I need to deal with.
Yeah, this seems like this kind of, where we're at right now, this case seems like you going to prison is a very high likelihood. So my guess is that we'll appoint you a lawyer and have some more thorough discussions about this case down the road. Is that what you want to do?
I really want to get it over with, sir.
Well, but the other case is not, we're not going to, the other case is more serious.
Yeah.
And it's not even on the docket today.
There's no way we can take care of it.
There's not.
Can I ask a question?
Sure.
I never knew that. I honestly never knew that I could get a felony 3 escape for cutting off a box. If that I wouldn't have never did nothing like that.
Okay. Well, with regard to the facts of that case, Mr. Allen, if Mr. Elter were here today, he would tell you that you have the right to remain silent in that, and you probably ought to exercise that until we get a little farther down in the road.
Yes, sir.
All right, I'm going to go ahead and appoint Mr. Elter to represent you in this case. That way you have the same lawyer for both of your cases, and we're going to set these out for resolution together. I do find there is probable cause to believe you have violated the terms of your supervision, and we have the affidavit of indigency for you to sign. I'll see you in probably about a week or so. All right, that's all. Next is the case of the state of Ohio versus Malachi Cameron. This is case 42793. Present before the court is Mr. Cameron, represented by Ms. Kirby, and we have Mr. View from the prosecutor's office. We are here today for a bond hearing. It's my understanding that Mr. Cameron is going to be entering a plea of guilty to 1 count of abduction, 1 count of domestic violence, and that we're going to set this for sentencing. Is that accurately stated?
That's correct, Your Honor.
Yes, sir.
Mr. Cameron, how old are you?
Just turned 21 a year, sir.
How far did you go in school?
I graduated.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
Right now?
Right now.
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case, Mr. Cameron. If you enter a plea of guilty to these charges, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation, also a determination to see if you're eligible for and appropriate for a community-based corrections facility. We're going to come back here in about 8 weeks for sentencing. The plan also, because you've been accepted to the coach program, is to release you from jail on a monitor into that program pending the sentencing. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Kirby before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of abductions, 3rd-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. It would, if I sent you to prison, also carry with it a mandatory period of post-release control of anywhere from 1 to 3 years. The domestic violence is a 3rd-degree misdemeanor. It carries with it up to 60 days in jail. Before we go any further, Mr. Cameron, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View, we've had the opportunity to get the input of the victim on this.
Yes, Your Honor. We've had discussions with the victim, Brianna Phillips, regarding the resolution, and she's in agreement with as detailed in the plea form.
All right, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on June 7th of 2025 in the city of Franklin, Warren County, state of Ohio, the defendant at that time was residing with Brianna Phillips, a family or household member who was pregnant at the time, and the defendant did threaten physical harm to her and by threat did restrain her liberty.
Anything on those facts, Ms. Kirby?
Nothing on the facts, Your Honor.
Mr. Cameron, did you hear those facts?
Yes, Your Honor.
Do you admit that they are true?
Yes, Your Honor.
Do you understand the rights you're giving up by entering a plea of guilty?
Yes, Your Honor.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I am going to grant you an OR bond. I'm going to make the condition of your recognizance bond that you are to enter into and successfully complete the coach program and be on electronically monitored supervision with a curfew. We'll see everybody back here for sentencing in 8 weeks.
Okay, thank you, Your Honor.
Thank you, Your Honor.
See you soon.
Can you do the EM referral?
Another 400 or 500.
I'm gonna give you time over to pay this.
Okay,
I'm not looking.
I'm a stay-at-home mom, so looking to get back in school.
All right. Did you review this report with your client? And are there any material additions, corrections, or deletions?
Yeah, we did review the report. There are no additions, deletions, or corrections. The updates that she gave me are already in here. She's gonna be transitioning from the new Oakland into the Guidance Center. And she has her orientation on September 5th, 2025.
I spent over $600 at New Oakland Family Center just to come realize that it doesn't count toward my probation. So I've almost completed that program and dropped a whole lot of money that I didn't have to.
Wait till the probation officer comes in that's been working with you. What else?
Other than that, Judge, there's no additions, deletions, or corrections. She did indicate to me, we went through that list of recommendations from probation. And Ms. Garrett just stated that she's already doing a lot of that. She also
She
got
is,
her-
but she's paying for her testing right now. We're gonna start to pay for it. She's gonna pay for,
But then I gotta pay 400, so, right? Okay. Do you wanna see my list of meetings?
no,
Okay.
that's why we have Ms. Tessino and other probation officers here. Your name?
Emily Tessino.
So she's kind of questioning the fees, and that's understandable. It's a lot of money. Nobody's gonna debate that with you. I want to sentence her, but I want to make sure that I'm not missing anything. This one's a little unique because she was already in regular probation. Have I let you finish?
Yep. Unique is the right word for it.
At least you're bubbly. I need bubbly. Huh? I don't need people getting angry and yelling.
No, dude.
All right, we're gonna help you.
Okay, that's what I'm hearing.
You know, seriously, you know how good this made us feel? We had somebody graduate yesterday. She did a great job. She was a mess, to be honest with you. I'm not gonna mention her name, and then she graduates, and you can just see what a difference in 2 years she's become. And you're gonna see those stories all over. I hope you're one of them. 20 months probation going forward from this point. You cannot leave the state without the consent of the court. You cannot violate a law. You have to comply with all agreements, guidelines, and requirements as indicated in the sobriety court handbook. You're to notify your probation officer of any change of address. You have to report as often as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing on demand of probation. They're going to explain it. But right from now on, you're going on our dime. We have grants to cover this. Submit the PBTs, ETGs, and chemical testing on demand of probation. I want you to complete 60 days on the sober link starting today on our dime again. Attend 12-step meetings 3 times a week and provide written proof of attendance. Obtain an AANA sponsor. Attend all substance abuse treatment in an approved facility. Attend the Victims Impact Panel. Attend and complete the Armed Specialty Court Weekend Program. Report to sobriety court status review hearings with me every 2 weeks. Obtain and maintain employment. You have to provide proof of that to probation. I've already ordered. You haven't done 3 days on the court work program, but you did pay for those, right?
Correct.
So I'm not going to charge you for those. I'll just make a note, already paid CWP fees. You do have to pay not $480 in probation fees because you already paid $240. So I'm going to order you to pay $240 in probation fees. I'm going to order that you go, and I'll stick with, well, it's $15 a month times 20, so it's $300 in sobriety court fees. So you're up to $540. You already paid your victim's rights fee. You already paid your justice assessment fee. You already paid your screening fee. So that should leave nothing left to pay other than $540. I want to double check that with you though. If you violate, your probation could be revoked and you could be incarcerated in this case for a period of 93 days with credit for 1 day served. Now, I want to make sure, and you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. I want to make sure she was given proper credit for everything. I think she was.
You mean in terms of the money?
Yeah. I think she only has to pay $540.
Yeah, because the original term was, let's see, was 12 months, I believe. So yeah, it'd be 12 more months of supervision.
So I'll let you pay those at the rate of $65 per month, and I'll start this beginning October 1. And you do that, and you'll have this paid in about 8 months. Can you do that?
Mm-hmm.
Yes?
Yeah.
I look forward to this, Ms. Garrett. I hope we can help you.
I hope so too. I look
methamphetamines for cocaine and marijuana. Also, there have been some curfew violations and some other violations of the CR plan. He has been served with a copy of the citation in contempt and also with the summons. I do find that Mr. Stover is indigent for the purposes of hiring a lawyer in the case, so I'm going to appoint Mr. Acello. Mr. Acello, how is it that we want to proceed today?
Your Honor, we formally offer a plea of not guilty in this matter. At this time, Mr. Stover is preliminarily seen the violation in the summons. I'd ask the court to set this matter for a contested hearing. I don't believe it would take longer than an hour for that. As I indicated in our discussions, I accidentally left my phone outside, so I'll get a date with Ms. Idle. Mr. Stover indicates that he did not test positive. I don't know what else to offer at the moment.
All right. Court finds that there is probable cause to believe that Mr. Stover has violated the terms of the conditional release plan. I am going to take him into custody today. We'll set it for a final contempt hearing in about a week. You wanted to tell me something, Mr. Stover?
Yes, Your Honor. I've relapsed. Part of my addiction, the whole of my addiction is intimacy and lovemaking. And my ex came over the time that I failed before, and I didn't know that she was bringing drugs, but since I'd relapsed, I scheduled IOP for Lender Center. I scheduled to go into IOP today at Lender Center to handle intensive outpatient treatment just for that relapse. I haven't had a problem. I can test positive for nothing today, and I haven't had a problem since the 11th. I don't see how cocaine was on there. Maybe it was mixed with methamphetamines that I thought that I tested clean that day, but I don't remember using that week, if I'm being completely honest. But I do have IOP scheduled. If you let me stay out in the community, I can continue with IOP.
No, I'm not willing to let you stay out in the community. We are so familiar with this path.
I've never done anything wrong in the community, though, since the fire. I haven't done anything to anybody or myself, harm myself or others in the community. I feel like this is all drug addiction related, and my drug addiction has to do with intimacy. I got caught. My ex came over with drugs, and I couldn't say no, and we made love that night. And and then I relapsed after that. I still had some after that. I found some in the house when I was cleaning after that.
So here's where we're at, Mr. Stover. Really the same place that we've been for a while, and I don't want to step on your attorney's advice to you that he might be giving you in this case already, but you are not on probation. You are not on supervision with me. You are on a conditional release plan because you were found not guilty by reason of insanity. That means that I put down a court order that says I am releasing you into the community based on some conditions. You have to follow those conditions, and when you don't, then I revoke that conditional release, and really I ought to send you back to Summit, and you ought to spend the next 4 to 6 months in Summit and let them deal with it. But I really don't want to go that way because I don't think this is a product of your mental illness. I think this is a product of your behavior, and we got to try to manage it how we can. I'm going to set it for a final hearing in the next week or so, and we can talk about what additional interventions that we want to make in terms of drug and alcohol treatment. Sort of have a PhD in outpatient treatment already, but that's where we're at.
That's why I said intimacy is my biggest flaw when it comes to addiction. And I could not say no that night. I don't know what else to say. And it caused a little hiccup of attempts after that. I'm not sure what else to say other than I know what my triggers are. And I haven't went back to my ex since. I haven't relapsed. I haven't done any methamphetamine for the past I think it was about 6 months. It was about my 6-month mark. I've been doing great. I haven't had any urges to use, and then my ex got involved, and the only thing that really makes sense to me is that to get back on the horse and be sober. Get back up on the horse, be sober, do what you can do, use your coping mechanism.
All right, that's all.
So I understand how taking me to jail helps anything.
I'm sorry, Mr. Stover?
I don't understand how taking me to jail helps anything.
Part of this is just keeping the community safe, Mr. Stover.
What do I
But
do?
talk to your attorney about that and we'll talk next time out.
Is this your battery? You got a monitor?
Towards the extra treatment.
Good. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Did I cover everything?
I haven't had a probation one in a while, so I felt the same way you did.
Have a great day.
Thank you.
Good luck. Thanks.
Thank you.
Thank you. Torrance, Antoine Leishon Torrance, 25B1486818 and B. What else do you have, Mr. Teo? I'm going to take yours next.
Jonathan Johnson, 12 Nolan.
Okay, you remind me when I call those. Sir, your name?
Antoine Torrance.
How you doing, Mr. Torrance? You have a possession of a controlled substance, crack, and then you have defective equipment, a crack in your windshield. So you have those two charges. You have the right to a lawyer. Do you want one?
Say what? Possession of what?
Controlled substance, crack cocaine.
Yeah, that wasn't what.
I'm not saying, listen, that's what the ticket wrote. Defendant was possession of crack cocaine and had a large crack in the windshield. I don't write these tickets. You might be right. Maybe you didn't have anything. I don't know. I'm just telling you what the charges are. Do you want a lawyer?
Yeah.
We'll get you a lawyer. Give him a lawyer, please, and then we'll go from there. And this thing has to go down to Jennifer. Make sure you take that right to Jennifer. That's important. Franklin, Michael Anthony Franklin, 25B1498148 and B.
Yeah, we have Mr. Franklin, state your full name, please.
Michael Franklin, Your Honor.
How you doing there, Mr. Franklin?
Good, Your Honor.
He's going to plead to allowing unlicensed driver to drive. They're going to dismiss the suspend. He's going to plead to distracted driving. They're going to dismiss the using a mobile device while operating a vehicle. True?
Correct, Judge.
Is that what you want to do, sir?
Yes, sir.
If you plead to distracted, that's 0 points. It won't go on your record. If you plead to allowing an unlicensed driver to drive, that is punishable by up to 500 fines, 90 days jail. Costs for all those, but that's 0 points and the suspend would be dismissed. Do you understand that?
Thank you, Your Honor.
Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? To the charge of allowing an unlicensed driver to drive, how do you plead?
Oh, guilty.
Were you in control of a 2005 Chrysler that was being operated on Telegraph northbound near Struan and Brownstown at 10:07 a.m. on the 22nd of July of 25?
Yes, sir.
And did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
And to the civil infraction charge of distracted driving, responsible or not responsible?
Responsible.
I'll accept that plea. I'll accept the plea to allowing an unlicensed driver to drive. I'll dismiss the suspend. I'll dismiss the using a handheld device. And accept the plea to distracted. So we're going to sentence on distracted, sentence on allowing an unlicensed driver to drive. The suspend's dismissed, using a handheld mobile device while operating a vehicle is dismissed. Ready for sentence?
Yes, sir.
Anything?
Yes, Judge, so for the distracted driving, he already paid some money. He paid the ticket for the use of the mobile device. But I guess he was putting in his bond money because that does actually.
Lisa, is that correct?
Let me check.
He's got a receipt, Judge.
You're revoked. What are you driving on a revoked license for?
He's working to get it back, Judge. He completed that application, for his administrative hearing as Secretary of State.
All right.
He made
Yeah, it
that-
looks like, sorry.
It's okay. Go ahead.
It looks like he paid it and then we just posted it as a bond since he had this pending hearing.
You have that to apply.
Yes, sir.
I don't like the driving on revoked, though. I want to be honest with you. I mean, you haven't had a ticket in 15 years, at least on here, but
Oh, no, sir. I'm getting rides now, as a matter of fact, until I can get my stuff, in order.
anything else you want to tell me?
No, sir.
Just as it relates to fines and costs, Mr. Franklin only received Social Security, Judge, so he may need a payment.
Fines and costs on the distracted are 200. And the allowing unlicensed driver to drive, 100 fines, 180 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees, 445 or 90 days. So you have 445 plus 200 for 645 is bonds for how much?
215.
215.
215.
Okay, how much can you pay today?
I like to pay it all, sir.
You can pay it all?
Yes,
All
sir.
right, that'll apply to the others. Sir, you have to take your hat off, please. You go down the hall and work that out with my judicial clerk and you're all set. Best of luck. Thank you.
Thank you.
Good to see somebody smiling besides me, huh? Jay Nolan. Jay Wall Orion Nolan, 25B148261. Mr. Nolan, your name?
Jake Will.
How old are you, Mr. Nolan?
22.
Okay. You staying out of trouble?
Yes, I counsel.
Counsel, does he stay in mute, wait formal reading?
He does, Judge.
And then
I
he's-
have it to you on behalf of Mr. Nolan.
And then he's going to plead to suspend, right?
Yes, Judge.
Is that what you want to do?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. You understand that?
Yes, sir.
Did you sign, read, and understand and advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
Yes,
To
sir.
the charge driving on a suspended, how do you plead? Were you operating a motor vehicle on Gibraltar near Allen and Woodhead and Brownstown, May 31 of 25?
Yes.
Was your license suspended, revoked, or denied?
Suspended.
Are you on probation or parole?
Yes.
For what? Anybody force you to plead guilty?
No.
By pleading guilty here, I want you to understand this would be deemed a violation of that probation or parole. That probation or parole could be revoked. You could be in prison on that charge as a result of this plea and conviction. Do you understand that?
Yes.
Anybody force you to plead guilty?
No.
Please accept it. I've never, you know how many warrants you got?
I'm trying to take care of it.
You're not trying to take care of
I
them.
just got out of jail on Friday.
I hope you have some money to pay because I am not giving you a payment plan and letting you walk out when you have somewhere in the neighborhood. I don't even know if I can count this high. He's got to have 40 warrants on here.
Your Honor, so I guess there was a ticket he had before Judge Heston. I guess he got time served on that ticket. I don't know.
Good for her. That's nice of her. But time served.
I'm not sure of the facts of that situation, Your Honor.
Judge, he had multiple cases. He just saw her recently while he was in custody.
I get it.
Your Honor, I would say he's gonna be monitored, right? I mean, I know the court may not want to go if he can't pay anything today, but he's on felony probation, so he's definitely.
Well, I didn't say anything about placing him on probation. I can't look at a guy with 40 warrants and think that he's coming back here to pay.
He will.
Oh, I'm sure. He's thumbed his nose at all these other judges and somehow I'm so special.
I'm trying to.
He'll come back and
Take care of all of them while I was incarcerated, but they denied all of them.
Who did?
36th District.
That's where the majority of those tickets come from.
You want me to really,
Probably one of the
you
comments.
want me to really go through these? 1, 2, 3, 4, 5, 6, 7, 8. Everybody acts like it's okay to abscond on the 36th. You know that? Everybody acts like it's okay to abscond on the 36th district court. Like there's some, well, that's okay. It's just 36. I don't get it. Detroit, you live in Detroit. That's close to you in Detroit. Right?
Yes, sir.
Well, why didn't you go over there? Of course they're not going to be nice. Look at this. You got 13 warrants other than Detroit.
Judge, he spent 90 days in jail. I know it was for an unrelated matter, but I would ask if the court can take that into consideration. I believe he'll come back and pay, Your Honor.
Where do you work?
I just was recently incarcerated, so I'm trying to find a job.
Where were you working before you were incarcerated?
I wasn't working.
Why? Why?
I'm trying to figure-
How old are you? You're 22?
Yes, sir.
You made up your decision to retire at 22. I love it.
I was
Well, why weren't you working?
trying to find a new job.
When did you last work anywhere and where were you working and how much did you get paid?
Last time I had a job, I was working at MJR.
And how many years ago was that?
I had like 2, 3.
Longer than that, wasn't it?
About 3, 4 years ago.
What have you been doing? No wonder you're getting in so much trouble. How can you eat if you don't work? Somebody's got to let me in on these secrets. How do you get to eat if you don't work? How do you put a roof over your head if you don't work? How do you put gas in a car if you don't work? How do you pay for a car? How do you pay for clothes? How do you do anything?
Entrepreneur.
Entrepreneur. And what kind of an entrepreneur are you? Tell me, what kind of an entrepreneur are you? Now listen, are we going to just kid one another or you want to just have a conversation here? It's time to grow up, entrepreneur. What are you talking about? What kind of an entrepreneur are you?
Man, I know how to work on cars and stuff like that too, so that's what I've been doing. If they don't believe me, that's just on you.
Are you licensed? What did he say? What'd you just say?
I said, if you don't believe me, then that's just on you.
That's on me? Is that what you said?
Yeah, if you don't believe me. I'm not trying to be rude. Not really too much I can do.
Well, you didn't tell me anything about working on cars. You said the last time you worked was at MJR. Did I misunderstand you? And that was 3 or 4 years ago. And then I asked you how you eat, and you said you work on cars. How much did you make working on cars, say, in the 1 year before you went into prison?
Like 4 years?
Yeah.
I wanted to say,
More than 5,000?
yes.
Do you have your own garage?
I got my own set of tools.
Are you a licensed mechanic?
I went to Votech career training facility in high school.
Are you a licensed mechanic?
No, sir.
Your Honor, again, he did just spend 90 days in jail.
I get it. I'm just trying to make him understand. That's all. I'm not trying to be a tough guy here. I just don't understand. You got to rethink your direction in your life. You really do. Who's this with you? Pretty girl. You know what happens? I got to tell you a secret. Pretty girls don't want to hang out with guys that don't have money and don't work and get themselves in trouble all the time. So you might want to give that some food for thought. I'm going to let you go. I don't see any reason to belabor this. I don't think you're going to listen to one thing I said, and I think you're going to go on and continue to act like you have. I hope I'm wrong. It's one of those situations I want to be wrong in. But you cannot go through life, and I don't understand this kind of thing. I see it every day. I just don't understand how you'll feel like 5,000% better about yourself if you're working and earning a paycheck. Do you know what I mean? You really will. I mean, I don't know what you do all day. I don't want to know. I don't need to know. But what do you do all day when you're not working? I don't understand it. I'm simply going to, that's all right. You got other fish to fry here. And you did right. I see you wrote a plea by mail. I tried to put you in front of the camera. So I want you to understand this is the beauty of the system. Listen to me. Listen to me. Just listen a second. We tried to get you in front of the camera. Defendant not put in front of camera, I wrote down July 3rd.
That was the jail.
I know. It was the jail's fault. And I probably would have given you credit for time served then. And because you showed up today doesn't mean, and because this county didn't put you in front of the camera isn't your fault. I'm not going to penalize you for that. I have plenty of reasons to be a tough guy and give you time to go to jail here and sit there for 60 or 70 days. Because you don't respect the system. You really don't. You're not going to. I'm not going to be a tough guy. I might talk a little tough because sometimes, some way, I want to get letters like I got and saying, Judge, you turned my life around like I got a couple of weeks ago from people that were in front of me 15 years ago. Maybe, just maybe, you're going to be one of those long after I'm gone from here. Write me a letter, sending it to the court saying, give this to McNally. He at least said some things to me that made me think twice, and I at least went out and made a living. I'm just telling you. This thing called life goes awful quick. You're hanging out on the streets. You're up to no good. You're not working. You're up to no good. You know what I know. Just that simple. But I'm not going to sit here and chastise you anymore. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 or 30 days credit, 30 case closed. I hope you think about what I'm saying, though. You'll feel so much better about yourself if you work. We have this thing called self-esteem, and all of us need to boost it for ourselves. Good luck to you. I really wish you well. I'm not trying to give you a hard time. I just hope you'll think. You seem like a nice kid who just doesn't respect authority. I'd encourage you to work on that one, too. Good luck. Jonathan Patrick Johnson, 25B148931. A and B, and I also have 148932.
Dion Padilla on behalf of Mr. Johnson. Mr. Johnson, state your full name for the court.
Jonathan Johnson.
All right, I gave him permission to appear by Zoom, did I, Lisa?
Yes, he doesn't have transportation, he can't drive.
Okay, so you're going to plead guilty. He's going to plead guilty to operating while intoxicated. He's going to plead guilty to open intox. I also have 931C, which somehow got stuck. That's resist and obstruct. They're dismissing the resist and obstruct. They're dismissing a PBT refusal. He's going to plead to OWI and operating while intoxicated, correct?
Correct.
Is that what you want to do, Mr. Johnson?
Yes, sir. Yes, Judge.
Possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points on the OWI. I'm sorry, 6 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, Your Honor.
I got to have you keep your voice up nice and loud.
Yes, Your Honor.
If you plead to open intox, possible penalties are up to 100 fines, 90 days jail, costs are all those in 2 points. Do you understand that?
Yes, Your Honor.
And you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes, Your Honor.
Now, you had a prior drunk driving out of Ohio, true?
Yes.
Are you on probation for that?
No, sir.
Are you on?
No, sir.
Sir, are you on probation or parole?
No, sir. Neither one.
Anybody force you to plead guilty to this charge?
No, sir. No, Your Honor.
To the charge operating while intoxicated, how do you plead?
I plead guilty.
To the charge open intoxicants, how do you plead? Open intoxicants, how do you plead, sir?
I was trying to plead to that. Well,
I just need to know how you plead. If you don't want to do this deal, you don't have to.
I didn't know that bottle was in the car. I don't know how to. I just never knew it was there.
On the car.
I do, Your Honor.
At some point, you knew it was in there, right?
No, sir. I had family I was dropping off. There was people in the back seat, and we were just going home.
What do you want me to do here? He's got it now.
I told him he can set it for trial.
You want to set it for trial? Is that what you want? I mean, look, I don't want you to plead guilty to something that you didn't do. If you didn't know the open intox were in the car, I don't know how you couldn't have known that, then you shouldn't plead to it. But that's okay. If you didn't know, you didn't know.
I didn't, so I don't plead to it because I never knew it was back there until the officers. It was in the back seat. I'm driving after I dropped them off.
Hang on. I'll end the prosecutor. Let me go on the OWI case. Were you operating a motor vehicle on Telegraph near Emmels in Brownstown, June 27 to 25 at 11:50 p.m.?
Yes.
Did you drink alcohol prior to operating that vehicle? And if so, what did you drink and how much?
We were in that complex there where
I just want to know how much you drank and what kind of.
I think I had like 3 shots of Tito's.
Was your ability to operate the motor vehicle significantly and materially affected due to the consumption of the alcohol? And if so, in what way?
No, sir.
Well, you were pulled over, and do you know why you were pulled over?
Well, I was kind of coming out of the complex, so I was going left, but there was a car in front of me across in the parking lot. Not knowing what it was, I was allowing them to go, but they didn't go, so I kind of like gassed it a little bit to get out and beat traffic because I didn't know, I couldn't see if they were trying to come out or not, but the whole time they were officers. So when they felt the need to pull me over because I guess, by me pressing the gas a little bit, they pulled me over. And so I put my blinker on and I slowed down. I wasn't even going over 30 and I was trying to find the shoulder.
My question.
Mm-hmm.
Did you feel a little bit intoxicated?
I wasn't necessarily.
We can set it for trial. I've explained, I'm not even comfortable with a plea if he wants to set this for trial.
If you want to set it for trial, we can do that, sir. Yes, I don't want you to feel pressured to do anything here. It's the United States.
I have no transport. I have no way out there. Even if I did set one, so I was just trying to see what I can work out.
Counsel, were the breathalyzer, or was it a blood test or breath result? Your name?
Blood test.
It was blood, it was a 0.133, Your Honor.
All right. You stipulate that was an accurate reading?
Yes, I saw the report I have the police report. I have the test. And it's 0.13, it was a 0.133.
All right. I mean, I'm satisfied. That's UBAC. That's still operating while intoxicated. If you are, I'm not satisfied on the open intox. Hang on, Mr. Johnson. Mr. Johnson, would you just let me work on this for a second?
Yes,
you want to do something else and dismiss the open intox and maybe even plead the PBT refusal or something else or impeding traffic? I could care less.
I guess we can talk about it.
You want to talk about it right now?
I mean, I would be willing to give him resistant hinder, Your Honor, but it's my understanding that he doesn't believe with that either. So,
Mr. Johnson, do you think you did anything wrong?
I was going home. I was just dropping my family off when we were coming from another, a little gathering. I was dropping them off. I did take a couple sips when we were in the trailer or whatever or whatnot, but I'm not aware of what was left in my back seats. I don't even know the amount. I don't even know anything. All I knew is I was just coming out and I was going home.
I'm going to hand these files back to your lawyer. I'm not taking any plea. She's going to go and talk to the prosecutor, and they're going to see if they can work something else out. Okay?
Thank you, Judge.
Do you have
Thank you, Your
Schaefer?
Honor.
Chance? Do you have Joshua Schaefer?
Infiltrate, Your Honor.
Okay, Joshua Edward Schaefer. Just don't go anywhere, Mr. Johnson. We'll be right with you. Joshua Edward Schaefer, 25B149-261A and B. Your name, sir?
Joshua Schaefer.
All right, so you want an adjournment? We'll give you a brief adjournment, couple weeks. What do you have for me, Lisa? What?
I get paid bi-weekly.
So
I know I have some fines to pay to get my license.
all right, we'll give you 4 weeks. I can't go more than that. Give me 4 weeks, Lisa.
September 18th at 8:45.
Is that gonna help you?
Yes, sir.
That's a little more than 3 weeks. Is that gonna be enough time?
Yeah, I appreciate it. Yes, sir.
Or do you need me to go a couple more weeks? I can do that.
Honestly, it's quite a few thousand in fines I have to pay.
You're not gonna be able to pay them anyway, are you?
I'm not all right away. I'm just.
Lisa, give me.
Judge, yeah, we can do the 24th also, September 24th at 8:30.
We'll do September 24th at 8:30. We'll see how you're doing. How's that?
Absolutely. Thank you so much.
All right, go down the hall. September 24th at 8:30, and they'll give you a notice, okay?
Yes, sir.
All right, best of luck.
Thank you so much.
You're welcome. All right, what else do we have here? What do I have? What do you have? What's his name?
His name is Barry Bailey. He was supposed to be here yesterday.
You wanted the defense attorney?
Situation.
Do we have a daily file down there, Lisa? Did you check it down the hall?
Yes, sir. Bagley.
Bagley.
B-E-G-L-E-Y.
Begley. So we'll pull your file. Man in the back, I'm sorry, what do you have?
She goes to office, you send the files with the team after attorney to everybody before us.
Huh. We'll check into what's going on out there.
Bagley's a walk, so may have that file. Yeah.
Did they bring Demps back in yet?
Yeah, I just got.
You just did, yeah.
Okay.
Apologize, I literally.
What do I need Demps in here for?
He has weapons, so they wanted to talk to you about that.
DeKale Cortez, where's Mr. Haynes? I need Mr. Haynes in here on this. Mr. Haynes was the lawyer representing him. DeKale Cortez Demps, 25B706-301.
Yes.
Give me 1 second. I'm going to get your lawyer in here.
Can you send that one back on Josh? He'll be in.
Detective, your name.
Good morning again, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
I don't know if he's zooming or what he's doing. Yeah, I need Mr. Haynes.
Zoom, Judge.
Mr. Haynes, your name?
Sherwood Haynes, we have Mr. Demps.
I don't know what's going on. So I was told there's something about a weapon. What's going on this?
Your Honor, it was my understanding that you said that he was not to possess any firearms or dangerous weapons, but there was no designation by the court on what you wanted Mr. Demps to do with the firearms that he already possesses.
Surrender them to the police. You're to surrender your weapons to the police. Do you understand that, sir? To the Brownstown Police Department. Do you understand that?
Yes.
Have you posted your bond?
No, not yet. No, we're still waiting on the paperwork.
Surrender to police by the end of the day. So you got some moving around to do. You got to go out to Warren. You got to go to Brownstown. Get somebody to bring them if they're legally. Where are they? At your house?
Yeah, they're at home. Yes.
And you live in what city? Detroit? I thought
I live
said
in
Brownstown. Okay, well, you're nice and close. You can go over there and get those after you post your bond, bring them over to the police department, and then go to Warren. How's that?
That's fine.
All right. Anything else, Detective?
No, Your Honor, my apologies for this. Thank you.
That's okay. Have a good day. Thank you.
You too, thank you.
What else? And Mr. Begley. Do you have the Begley file? Is the Begley file ready yet, Lisa, or not?
It would have went to the arraignment attorney.
Who's the arraignment attorney? Ours today. Mr. Haynes? Who has
I think those were Judge Hessen's, according to Stephanie. Let me look.
Mr. Haynes, do you have the Begley file? This poor guy's been sitting in here waiting. It was supposed to be here yesterday.
What was the name?
Begley, B-E-G.
I don't have that.
Do you mind doing me a favor and checking with Judge Hessen and seeing if somebody said is that who you think might?
Begley?
Yeah, B-E-G-L-E-Y.
It's a Judge Hessen case. It went into her courtroom. They like to see the files first.
Okay, thanks. It's in with her, I guess. Thank you. People against Johnson. Jonathan Patrick Johnson, 25B148931, A, B, C, and then I also have 24B 148932. Mr. Johnson, your name?
No, I put him in a breakout room. Let me move him.
So we're going to need a jury trial and a final pretrial date.
He's not moving. I got to close all the rooms.
Okay. Everybody good?
Yes.
Glad to hear that. Yes. All right, Mr. Johnson, your name.
Jonathan Johnson.
All right, I'm going to set a jury trial and the final pretrial date. I just want to be clear, you're going to have to figure out a way to get here for your jury trial date. Give me a jury trial date in about a month or so, Lisa. This is a July, well, I just arraigned him August 13th, didn't I? So we can set a final, let's just set another pretrial date in 2 weeks, and I'll worry about setting the jury then. How about that? September what?
September 10th at 9:45.
At 9:45. Defendant can appear by Zoom, okay? I'll let you do that, Mr. Johnson.
Thank you so much.
September 10th at 9:45. Are you working, sir?
Yes, sir, I am. And I pay child support.
How are you?
He works from home.
Okay, I pay child support. I love when people tell me that.
It's a whole
I mean, we all pay child support if we have children, you know what I mean? That's just the way it is, whether it's divorced or not. All right, we'll see you here September 10th. I wish you well. Good luck. Thank you.
Thank you.
I mean, all right. Do I have anything else? Ms. Amame, do you have anything ready for me?
Judge, I'm just writing up 3 police sheets for 4 no-shows, but one is an interpreter case that was scheduled at 10 o'clock.
Oh my God, let's get him out of here. Can you write that one up first, please?
I'll bring it right in, Judge.
They're going to have to cut everybody's pay around here to pay interpreters. I don't know what, it's okay in the case of the court officers, we can cut theirs. Lisa, is it just me? Does it seem like a lot of people we're getting interpreters for don't show up? Maybe it's just me.
Yes.
Because I know
Yeah, that's happening a lot.
Because I know how much we're paying for them, but All right, give me 1 second, please. And somebody's retrieving the Begley file for me, right? Do you know what that's about? Is that case assigned to me, Lisa?
No, it's a Judge Hessen case.
What, he didn't show up for what, an exam or?
Yeah, PCC, I believe. Yes, thank you.
I mean, is it the first miss?
I think they missed their PCC initially, but she arraigned.
How you doing there?
Good, Judge, how are you?
Nice to see you.
Nice to see you. Is it okay to approach?
Sure. How's things on the island?
Still afloat.
Still afloat?
How have you been?
I'm doing good, thanks. Beautiful day, but it means the fall's coming and the winter's coming soon thereafter, right?
Better get some golfing in.
I know, I gotta do more than I am. Is the interpreter here? Is this the Sanchez case?
She's in the jury room, Judge. I'll grab her.
Thank you.
Got it.
Hey, good to see you. I don't know what's going on with this guy, but I'm not really excited about this one. Mora Diego Sanchez. Mora Diego Fernando Sanchez, 255-415-027.
She said she'll be right in.
I kind of had it with this gentleman. All right. Is she working with somebody else or?
She was in with another court, Your Honor.
In Judge Heston's or?
No, she's in the jury room on Zoom with another court.
But she said she'll be right in.
I'm just going ahead and issuing the warrant for this gentleman. July 16th, I noted he needed a Spanish interpreter. July 30, the interpreter was here, defendant failed to appear. August 13, again, defendant failed to appear after apparently showing late on the 30th. And then somehow August 21, adjourn interpreter Spanish pretrial for today. I mean, I don't know what's going on, but I'm not playing this one anymore. I don't care. I'm setting 15,000, 10%. I've had an interpreter here at least 2 or 3 times and he didn't show up. So warrant issue, bond to be forfeited, 15,000, 10%. You can tell her we're done with her on this. I don't need her.
Thank you, Judge.
Thank you. You can make a note that Ms. Villarreal was here. Do you have the Begley file?
I do.
Good, bring it up here.
So,
It's gonna come in front of me.
okay.
Judge, she arraigned it, so it's going to stay hers.
I get it. That's okay. I'll just, here, hand me that, Tabitha. People against, Gary Wayne Begley, 25G, 718-253. Brian Brown. Your name? Name?
Gary Wayne Begley.
Where was he yesterday?
Judge, I was talking.
That's okay. Where were you yesterday?
Simpson made a mistake, Your Honor. I thought you owed the money. I looked at the paper next to Tuesday. I did call up here and the BV, this is a little bit paperwork I had. I seen that I know. They just told me to come here today at 10 a.m. I'll figure out.
All right, I'm gonna go ahead and reinstate the bond. You gotta show up though, okay?
Yes, Your Honor.
We're adjourning this, setting a new date, PCC. Lisa, when again? I'm sorry.
I never saw the file because it's not ours.
Yeah,
Is there a date on front?
I don't know if we gotta go to the 9th as a PCC.
It looks like he didn't show for an exam. So you want to set an exam date?
He didn't show for an exam?
Exam was supposed to be yesterday.
8:19, he was here for PCC, set for exam 8:27, or 8:26, sorry.
You tell me. This is going back in front of Judge Hessen?
Yes.
So we're setting it for September 9th at 1:15 PCC is what she wrote on here. Or you want to just set it for an exam? It's up to you.
I don't know, Judge. That's not my call.
I'll set it for September 9th at 1:15 PCC, September 16th at 1:15. You got to show up, sir.
Yes, Your Honor. I'll be here.
All right. Make sure you go down the hall, get your notice, put it on the refrigerator. All right.
Yes, sir.
Bond's otherwise reinstated. What's that? It was nothing that. Flee and elude, possession of narcotics and let me
Thank
just.
you, Your Honor.
Thank you. Flee and elude, let me just double check here. Flee and elude third, a 5-year, possession of cocaine and reckless driving with a habitual fourth.
Thank you.
Thank you. Make sure they give him this notice, okay? Thanks. Do you have anything for me?
I just got everything for you, notice.
Are we ready on it?
Yeah.
Who is it?
Al Kalanian?
People against, is this yours? Isam Mohammed El-Kalani, okay. 25B148862, your name?
Good morning, Judge Mesnick, Grand Avenue, Mr. Al Kalanian.
All right, he's not here, right?
No, I have authority.
You're gonna plead to 55 and 50, they're gonna dismiss the failure to yield to emergency vehicle, right?
No.
All right, and then, boy, it looks like he's got quite a record though, huh?
Yes, fortunately.
All right, so to that charge, responsible or not responsible?
Responsible.
Please accept the original charge dismissed, 185. I'm gonna give them until, September the 4th to pay, okay?
Thank you.
September the 4th.
Thank you.
Thank you. All right, people against Gongan, Dalian Odette Gongan, 25I-81674, defendant failed to appear. Defendant never showed, but we have to issue a show cause. Per the rules, defendant failed to appear, issue show cause. Finally, I'm gonna do, I think this is our last one. Bates, people against Jerome Moses Bates Jr., 25I-81673A and B. Defendant failed to appear, will issue show causes on both of these cases, issue show causes on those. And then, I also have here Sabatini, Jamie Renee Sabatini, 25I-81672. Loitering where drugs are kept per rule, I have to issue a show cause. So we're going to go ahead and issue a show cause. That's the first miss. I think that's it then, right?
No, I need to see who's in the county.
Oh, okay.
Yeah.
There's a couple sentencings that haven't been called.
Crawford has Austin.
Okay. You want to get him in here?
Still working on it.
Can I get your name in the county?
Alyssa Moore.
Okay, that's Miss Patillo's if we want to get her on.
We need Ms. Patillo.
All right.
I'll call her. What's the other one? Ms. Patillo, can you hear me? Can you,
Who's the female in the county?
Alyssa Moore, is she saying? Moore? I don't know who Alyssa Moore is.
Can we just take a break and figure out what's left?
Yeah, absolutely. Take 5 minutes.
They just took a small break. So I'll be on the outside. I'll come running for you.
All right, thank you.
Tell her she has one on Zoom.
Okay. Crawford. Haven't heard of it. I'll tag it. It'll sound nice music and.
How many cases? What else do I have?
I think that's the last one. We have some no-shows. Can we do that?
Yeah. Gilbert. Are we on record? Robert Allen Gilbert. 25B149144A. Then failed to appear. Issue show cause on the misdemeanor, default judgment on the civil infraction. Robert Eugene Markham, 25B149209. We're going to issue a show cause on the misdemeanor charge there for failure to appear. Ali Kamal Bazzi, 25B149126A, B, and C. On the suspend, we'll issue a show cause. That's file A. And on files B and C, default judgments are rendered for failure to appear. Devin Michael Riddle, file number 25B149312A and B. On the A file, we're going to issue a show cause for failure to appear, default judgment on the B file. People against. Crystal Denisha Wren, 25B148897A, B, and C. On the A file, issue show cause. On the B file and C file, default judgments are entered. People against McLaughlin. Ariana Anne Marie McLaughlin, 25B149179A and B. I'm going to issue a show cause on the A file for failure to appear, default judgment on the B file. Jamie Renee Sabatini. I thought I already did this. 258I81672. Yeah, I issued a show cause on that already. I believe on Bates too.
They was suspended the stack.
Yeah, that's fine. Sanchez, I already issued a warrant on. Miracle, Stephen Lee Miracle Jr., 25B148937. Warrant to issue bond to be forfeited $3,000, 10%. Jamal Dontrail O'Neill, 25B148992A and B. And on the A file, second misdemeanor to appear for show cause, warrant to issue $3,000, 10%. Default judgment was already entered on the other file. Sadie Costello, 25B149147. A and B on the A file, warrant to issue bond to be forfeited $3,000, 10%. The B file was already defaulted a couple of weeks ago on the 13th.
Please ahead and inform me.
People against El Maradi. Amir Fidel El Maradi, 25B144695.
Lisa, you there?
That one, he sent a plea by mail letter, but he's no longer in custody.
I'll just make a note. We notified him to appear here today, right?
Well, I sent a writ to the jail.
Okay, I'll just indicate not in custody, did not appear. Send him notice, Lisa, please. We'll just double check. I doubt he's showing, but we'll double check on that. Brianna Ray Bernier, 25B148694B.
Judge, that one she called and said she broke down. She was trying to get here, but I have not heard back from her.
I'll go ahead and reschedule this one. So, is this?
Yeah, yep.
What's the name on it?
Austin.
Let me see it. Can you guys tell by looking at the cameras, is he still in front of Judge Simpson?
Not the old, hang
Mr. Austin?
Yes.
We're gonna call down there.
Is Crawford still in front of Judge? Is Crawford still in front of Judge Hudson? He's not? Did Carl set something down? I'll come by. I'll get it. Thanks, man.
I knew that would happen. People against Joseph Bill Austin Jr., 25B149-106A. John, on probation violations, gotta make sure you're getting those advice of rights, the yellow advice of rights. Not this one, the other ones that were here today.
Oh, okay.
The blue backs.
Yep.
All right, come on up, Mr. Bill, your name?
Michael Crawford, representative.
All right, so does he stand mute, wait formal reading?
Correct, Your Honor.
And then he's going to plead to allowing unlicensed driver to drive, and the suspend will be dismissed. And then he's going to plead to distracted driving with the improper turn to be dismissed, right?
Correct.
Is that what you want to do, sir?
Yes.
If you plead guilty to allowing unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs are all those, 0 points. It won't get reported. Same with the distracted driving, 0 points. Do you understand that?
Yes.
Did you sign an advice of rights and read and understand those rights? You didn't sign this?
Oh, yes, I'm sorry, yes.
Did you read them?
Yes.
If you plead guilty, you're giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
You understand everything that's going on here?
Yes.
To the charge of allowing an unlicensed driver to drive, how do you plead?
No contest. But guilty.
You sound like you're on a game show.
I'm sorry.
You want to plead guilty, or what do you want to do here?
Guilty.
All right. Were you in control of a 2023 vehicle that was being operated on August 3 of 25 on Gibraltar near Old Fort in Brownstown at 9:02 p.m.?
Yes.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
Yes.
Anybody, you're on probation or parole?
Yes.
For what?
Driving.
Are you on probation to another court?
Yes.
Anybody force you to plead guilty?
No.
Do you understand if you're on probation to another court and you plead guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge. As a result of this plea and conviction,
Yes.
you still wish to plead guilty?
Yes.
Anybody force you to plead guilty?
No.
To the charge distracted driving, responsible or not responsible?
Responsible.
I'll accept the plea to allowing licensed driver to drive and distracted driving, dismiss the suspend, dismiss the improper turn. Counsel, you ready for a sentence?
Yes, Your Honor.
Is license been canceled? Why?
Your Honor, my client's picked up a few different offenses in the past. Currently is suspended because of a previous operating while intoxicated out of Ohio. He's only got a couple months left on that probation, so he's been compliant there. He understands fully, the court has explained that maybe he's moving forward. Your Honor, my client lives and works in Ohio. He commutes back because his fiance is here, so he kind of is in between two states. That's how I picked up this charge, Your Honor. Moving forward, my client intends to find an alternative means of transportation to work and avoid these circumstances. So he apologizes for this, Your Honor. The court can kind of take it easy on finding the cost. He appreciated it because, again, it doesn't matter, it's still paying.
Anything, sir, you want to say?
No.
On the distracted 180, on the allowing unlicensed driver to drive, 100 fines, 220 costs, 75 victims' rights fee, $50 justice assessment, 445 or 90 days. So you owe 625. Can he pay all that now?
No, he can't pay it all out.
How much does he have now?
He can't pay. Oh, no, you dig deep, Your Honor. He's gonna
Okay.
pay it all the day before the
Good
business.
good enough. I wish you well. Good luck. Stop driving when you don't have a valid license, okay? All right, best of luck to you. Thank you. Thank you very much. Good luck. People against Moore. Alyssa Dawn Moore, 25W8385889A and B. Ms. Moore, your name?
Alyssa Moore.
Who was your lawyer?
I don't know why she just left.
I don't know why I gotta hunt these lawyers down. I'm gonna need private investigators going forward, Lisa, to get these lawyers in here.
I'm not sure.
Slow down, Ms. Moore. Just relax. We gotta get your lawyer in here.
Okay.
All right.
Yeah.
Yeah.
Yeah, Petit on behalf of Ms. Moore. Ms. Moore, state your name for the court.
Alyssa Moore.
All right, she's gonna plead the driving on a suspended, the no proof to be dismissed, true? Is that what you want? You know I always called your case, right, Ms. Rulli?
Yes, Your Honor, I just wanted to say hello.
Thank you. Have a good day. Thanks for your help. All right, she's gonna plead to suspend the no proof to be dismissed, correct?
Yes.
Is that what you wanna do, ma'am?
Yes.
Plead guilty to this charge. Possible penalties are up to 500 fines, 90 days, 93 days jail. Costs are all those 2 points. And I'll dismiss the no proof. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury. If you plead guilty, you're giving up all those rights. You're waiving the right to a jury trial, waiving the presumption of innocence, waiving the requirement that they prove you guilty beyond a reasonable doubt, and waiving your right to remain silent. Do you understand that?
Yes.
All right. To the charge driving on a suspended, how do you plead?
Guilty.
Operating a motor vehicle, August 21 to 25 on I-75 near Vreeland and Woodhaven.
Yes. Guilty.
You got to keep your voice up, ma'am.
Yeah.
Was your license suspended?
Yes.
Are you on probation or parole?
I don't think so.
Anybody force you to plead guilty?
No.
Please accepted. No proofs dismissed. Something bugged me if I said 150 cash here, Lisa. What other cases did she have in front of me on Friday?
Was that a Judge Heston case?
Let me check.
She had one in front of Judge Heston.
She's in custody right now. Possession charge, I mean, very district, but it's a felony case.
She has a felony charge set for exam on September 9th.
She hadn't shown up before, right?
Correct.
I
Or I'm sorry, she's PCC on the second, exam on the 9th.
look at my files. I know how I think. What, why don't you show up, young lady?
I was on the Zoom and I ended up falling asleep, to be honest with you. I'm just gonna be real. And I was gonna turn myself in. I'm sorry.
All right. What do you want to say? Anything?
No, Judge, she's got felony case. I don't know if Judge would be willing to do time, sir. Because her bond is 15,000, 10%.
On the other case.
On the other case, yes.
I was gonna ask for rehab or something.
But that's for your other case.
Oh.
That's not my case, ma'am.
Okay.
On this one, 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 475 or 60 days. I'll let you pay this at the rate of $30 per week. I'll start that beginning on October the 22nd, okay?
Okay.
If you need more time, call the court. If you're in custody a long time, come talk to me. Maybe I'll give you a break on the fines. You got to grow up, though, young lady. You got to show up in court. Stay out of trouble. Good luck. Antoine Leishon Torrance, 25B148681A, B.
Deanne Petit on behalf of Mr. Torrance, thank you for going to court.
That's one, Sean.
Where in the world have you been? Huh? I'm asking you where you've been. I hate this. Why didn't you show up in court before?
because I was already incarcerated in the county jail.
You like courts, you like to go to jail. Well,
Not from this same, I went the same day. They drove me to the county.
does he stand mute, wait formal reading?
Yes.
Not guilty, please entered. Surety somebody wrote down here, July 29th. I don't know what that means.
Is that the 150?
Oh, you did post a surety bond for $750. Is that on this case, Lisa? I don't think so.
It looks like we did receive a surety of $750.
Yeah, why in the world are they saying a surety of $750 when I had a 10% bond?
Well, I think the surety posts like a quarter.
Yeah, I get it, but they shouldn't be. All right, well, look, I'll just go ahead and continue your bond. We'll give you a new date. You can fill out a petition for a court appointed. You gotta show up though. September what, 10th?
September 10th at 10 o'clock.
At 10 a.m., okay? You work, sir?
No.
Oh.
I'm on disability.
Okay, we'll see you September 10th at 10 o'clock. I wish you well. Thanks, Mr. Teal.
Thank you,
You
Judge.
do a nice job. I appreciate your help.
Thank you. Are we all set?
I think so. Lisa, are we done?
I think so. Bozzy and Riddle, they were no-shows.
Did I recall those?
I missed those two.
Yeah, there was sentencing, there were no shows.
Okay, yep, we're good.
All right.
Thanks.
Thank you.
Okay, you done? All right.
Thank you.
Is 360-533-0000.
Señor, va a ser por Zoom y el número con el que se va a conectar es 360-533-0000.
Me lo podrá repetir, permíteme, lo voy a anotar.
Allow me, I'm going to write it down. May you please repeat it?
360-533-0000.
360-533-0000.
Ok, está bien.
Okay, it's okay.
All right, have a good day, sir.
Bueno, señor, que tengan buen día.
Igualmente, gracias.
Same to you, thank you.
Who else was that you identified that did not want to participate?
¿Quién más no quiere participar en la corte comunitaria? ¿Alguien más?
Somebody else had that raised their hand, correct?
Me parece que otra persona había levantado la mano, ¿no es cierto?
Walter Logan does not want to participate. All right, he's gonna stay with me anyway. All right, this is the city of Detroit versus Connor Gap, War, case number SB 167-62491. Appearing for the record, please.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Gabor. You're muted, sir. Unmute.
Can you hear me now?
Yes. State your name.
Connor Gabor.
All right, good morning to you, sir. Day is date time set for a pre-trial. Mr. Berry is going to get you an updated offer. Keep in mind, if you don't like it, you have an absolute right to a trial. I'm going to put you in a breakout room with him. Let us know what you want to do when you come out, okay?
Thank you, Your Honor.
Join the room, please. Let's pass the matter. This is the city of Detroit versus LC Cruz, case number SP 1757086, counts 1 and counts 2. Appearance for the record, please.
Se llama el caso de Elsie Cruz. Números de caso SP175-7086, cargos 1 y 2. Diga su nombre para que conste en el acta, por favor.
Elsie Anayeli Cruz Morales.
Elsie Anayeli Cruz Morales.
Sí.
And good morning, Your Honor. Cherica Harris, P72832 on behalf of Ms. Cruz.
Y buenos días, su señoría. Soy Cherica Harris, la abogada representando a la señora Cruz, número de abogada 72832.
All right, good morning, to you both. Day is date and time set for arraignment.
Buenos días a las 2. Este es el día y la hora que había dado para tener una lectura de cargos.
For purposes of arraignment, my client stands mute.
Para el propósito de la lectura de cargos, mi cliente va a guardar silencio.
Ms. Cruz, I'm gonna enter a not guilty plea on your behalf and give you a $0 bond. Mrs. Harris is gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Join the room, have a conversation with her, let us know what you want to do when you come out.
Muy bien, vamos a procesar una declaración de no culpable para usted y darle una fianza de $0. Usted únase ahora a la sala para hablar con la señora abogada, donde dice join o unirse, toque ahí. Ella le va a conseguir usted una oferta actualizada de resolución. Si no le gusta a usted la oferta que le propone la fiscalía, recuérdese que tiene todo derecho de ir a juicio para pelear los cargos. Por favor, únase a la sala 3, donde dice join o unirse. Toquen la pantalla cuando la vea.
Elsie Cruz.
Yes. Can I get the iPhone to unmute themselves past the matter? Can I get the iPhones to unmute themselves, please?
Por favor, la persona que esté en el iPhone 3, por favor, abra su micrófono y diga su nombre.
And turn your camera on, please.
Y por favor también abra su cámara.
iPhone, unmute yourself. Turn your camera on.
La persona en el iPhone, por favor, abra su cámara y abra. Ahora
What is your name, ma'am?
¿Cuál es su nombre, señora?
Lucía López López.
Lucía López López.
Sí.
All right, good morning to you.
Buenos días, señora.
Bueno.
I'll see you.
Is it 8:35?
Yeah. All right. Gentlemen, you're gonna have to sit up, sir, on the iPhone. You have your camera on. Get down, mute yourself.
Señor,
What is your name,
usted en el
sir?
iPhone. Señor, ¿cuál es su nombre? Usted, que se le ven las cejas.
Come in the view of the camera so I can see you.
Señor, por favor, póngase en la cámara para poderlo ver. Usted, de la camisa azul. Por favor, siéntese. Usted, señor, de camisa azul. ¿Cuál es su nombre?
What is your name, sir?
Oh,
Yes.
Alejandro.
Señor, ¿cuál es su nombre?
Alejandro. Tavares.
¿Alejandro qué?
Tavares.
Alejandro Tavares. Alejandro Tavares. I don't see him, Your Honor.
Alejandro, do you have a case number, sir?
No,
Señor,
yeah.
tiene
Yes. SP 1747673
SP 17476.
732.
You have two case numbers.
I got two case numbers.
No, they're different judges, but different case number.
Okay, you need to go to courtroom. Ramsey Heath. What is Ramsey Heath courtroom? 427? 437. You need to dial into 360-437-0000. Do you need an interpreter?
No.
Señor, ¿usted necesita intérprete? No. he doesn't.
No.
All right, it'll be 437, 360-437-0000. If there's nothing further, sir, be safe and have a very good rest of your day.
All right. Thank you.
On Omar's iPhone, good morning to you. Can you unmute yourself and state your name, please? Full name. Sorry.
Señor, el señor en el que está en el teléfono de Omar, por favor, señor, abra su micrófono, su cámara y diga su nombre completo. Usted.
Hi, Omar Amoles Reyes.
He's the first one. He's a review.
City of Detroit versus Omar Amalis Reyes, case number ST1717111. Good morning to you. State your name for the record, please.
Good morning. My name is Omar Damien Amoles Reyes.
All right. Good morning. The date is the date and time set for a review. You were ordered to do 12 hours of community service. Let me see what the disposition was supposed to be. And I see that you completed those 12 hours of community service. We thank you for that.
You're welcome.
And we'll dismiss the case. You completed community service. If there's nothing.
You say I explained it well.
This is me. Are we on the record?
Yes.
Then I don't want to keep talking. You're not. Never mind.
I'm ignoring you right now.
I'm going to quote directly from the jury instructions. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You must decide. That's what I'm going to say. I'm going to say that they are the sole trier of facts. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all of the elements of each count beyond a reasonable doubt. I mean, I'm literally quoting directly from the jury instructions, but without giving them any specific direction. We had this happen before with a felony murder case where they.
John Arnold and there was somebody else where they came back guilty on felonious, but not the murder.
And I have my suspicions, but I know on that one, there was one juror that was simply not going to budge. But I think that this is what my answer. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. It is your duty to decide from all the evidence taken together whether the state has proven all of the elements beyond a reasonable doubt. Any objection?
No.
Will? No. All right. Nothing like trying to give a cryptic response to an answer to a question. All right, let's go off the record.
So here's the $1 million.
Brother Mr. Reyes, have a very good day. Best of luck to you, okay?
Thank you. I can log out?
You can.
Thank you.
What was his name? I said Tom, very top name. Oh, I'm over this. On the iPhone, I just let you in the room. Good morning to you, sir. Take your hat off, please. What is your name?
Good morning, Your Honor. My name is Joshua Castillo Aguilar.
Good morning to you, Mr. Okay, this is the city of Detroit versus Joshua Castillo Aguilar, case number SB 15990561. State your name for the record, please.
Joshua Castillo Aguilar.
All right, today is the date and time set for review. Let's see. You were ordered to pay $240. I see that you paid the money. And this was a 12-month delayed sentence. And I'm going to dismiss the case, sir. You haven't gotten any other trouble, paid the money, and we're going to close the matter out. Best of luck to you, sir. Have a very good rest of your day.
Thank you, ma'am. Appreciate that.
All right. Let's go back on the record with Mr. Cruz. Mr. Cruz, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Volvemos en el acta con el caso de la señora Cruz. Señora Cruz, le di la oportunidad de hablar con su abogada en una sala privada de consulta. Díganos qué van a hacer, abogada.
Your Honor, my client is going to enter a plea to the amended count of allowing.
Su señoría, mi cliente va a presentar una declaración al cargo modificado de haberle permitido a una persona sin licencia a conducir.
Is that what you want to do, Ms. Cruz?
Y señora Cruz, ¿es eso lo que usted quiere hacer?
Sí.
Yes.
Can you raise your right hand, please?
Levante su mano derecha, por favor.
You swear or affirm to tell the truth, whole truth, and nothing but the truth?
Jura usted, declara solemnemente que va a decir la verdad, toda la verdad y nada más que la verdad.
Sí, lo juro.
Yes, I swear it.
You can put your hand down.
Ya puede bajar la mano.
Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Y comprende usted que la penalidad máxima en este caso pudieran ser 93 días en la cárcel y o un máximo de $500 en multas?
Sí.
Yes.
Do you understand that you have an absolute right to a trial?
¿Y comprende usted que usted tiene un derecho absoluto de ir a juicio?
Sí, igual.
Yes, I do. Same.
Ms. Harris went over your other advice and rights in the breakout room, did she not?
Y la señora Harris revisó con usted sus otros derechos constitucionales cuando estaban en la sala privada de consulta, ¿no es cierto?
Es cierto.
That is true.
And you understood those rights?
¿Y usted comprendió sus derechos?
Sí.
Yes.
Do you have any questions about those rights?
¿Alguna pregunta que usted tenga acerca de sus derechos?
No.
No.
You know by taking the deal, you're gonna give those rights up?
¿Y sabe usted al aceptar esta oferta de resolución, usted renuncia a esos derechos?
Sí.
Yes.
Has anybody offered you anything other than what's been stated in the record?
¿Y alguien le ha ofrecido a usted algo diferente de lo que ya hemos hablado en el acta?
No.
No.
Let me draw your attention back to July the 16th, 2025, at around 3:43 p.m. in the city of Detroit, in the area of Spring Wells in Panama. Did you have an occasion on that day to come in contact with the Detroit Police Department?
About what time was that, Your Honor? May I ask? Interpreter asks.
2:43.
2:43. Thank you, sir. Así que entonces, señora, permíteme llamarle la atención a la fecha del 16 de julio del 2025, aproximadamente a las 2:43 en la tarde, en la ciudad de Detroit, en el área de las calles de Springwells y Panamá. ¿Tuvo usted ocasión de encontrarse con un policía del Departamento de Policía de la ciudad de Detroit?
Sí.
Yes.
Were you operating a motor vehicle?
¿Iba usted manejando un vehículo motorizado?
Sí.
Yes.
Officer asked you to produce a valid driver's license.
Y el policía le pidió que usted le enseñara una licencia vigente de conducir.
Sí.
Yes.
You could not do so, could you?
Pero eso usted no pudo hacer, ¿no es cierto?
No. No.
No.
Tengo.
Why is that?
¿Y por qué razón?
Porque no lo he podido sacar.
Because I haven't been able to get a driver's license.
Very well. I'm going to find your client guilty of the amended count of allowing. In order for her to do 12 hours of community service, I'll dismiss upon completion with stipulation of probable cause. I'll dismiss the other matter now.
Entonces vamos a procesar una declaración de culpable para su cliente para el cargo modificado de que le permite a una persona sin licencia a conducir. Voy a ordenarle a usted, señora, que haga 12 horas de servicio comunitario. Una vez que las haya cumplido, su caso queda desestimado. Y licenciada, si ahora usted me puede estipular que hay causa razonable para desestimar el otro cargo, lo haremos ahora mismo.
Sí, está bien.
So stipulated, Your Honor.
Sí, así lo estipulo, su señoría. Yes, that's fine.
Is 313-318-7426 the best number to reach you?
Y dígame el número de teléfono 313-318-7426, el mejor número de teléfono para que nosotros nos pongamos en contacto con usted.
Sí.
Yes.
Do you have the number to the Southwest Detroit Community Justice Center?
Y ya usted tiene el número de teléfono para el Centro de Justicia de la Comunidad del Suroeste de Detroit.
Sí, ya lo tengo.
Yes, I've already got it.
I give Mr. Phillips or Ms. Quinteo a call this afternoon. Set the hours up. I'm going to give you until September the 17th to complete the hours. If you don't have anything further, I wish you the best of luck and have a very good rest of your day.
Muy bien, entonces llame esta tarde a ese número de teléfono. Pida hablar con el señor Phillips o la señorita Buentello para que puedan hacer los arreglos para el trabajo que usted va a hacer para la comunidad. Yo le voy a dar a usted hasta el 17 de septiembre para que alcance a hacer sus horas de servicio comunitario. Si no tiene alguna otra pregunta, le quiero desear muy buen día y buena suerte.
Sí, muchas gracias.
Yes, thank you very much.
I have a very good day. Best of luck to you.
Y que tenga muy buen día y muchísima suerte usted, señora.
Gracias igualmente.
Thank you, same to you.
This is the city of Detroit versus Terry Daniel, case number SP 1760916, counts 1, 2, and 3. SP 1760949, counts 1, 2, and 3. Appearance for the record, please.
Sharika Harris on behalf of Defendant Daniel, please state your name for the record. Terry Daniel, unmute your device.
Terry Daniel.
For purposes of arraignment, my client stands mute.
Well, here or not guilty plea in your client can have, give your client a $0 bond. Get Mr. Daniel updated offer. Mr. Daniel, Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Right.
Join the room, we'll pass the matter. Let's go back on the record with Gab. The bar case, I'm giving you an opportunity, Mr. Gabar, to speak to Mr. Berry. Mr. Berry, what does your client want to do?
Your Honor, my client would avail himself of the people's offer to enter a plea as charged on the basis of a delayed sentence, hopefully to be dismissed at the end of his community service.
You want to take the deal, sir? Mr. Gabar?
Sorry, I didn't hear you.
You want to take the deal?
Yes.
You said that? I didn't hear you.
Yes.
All right, can you raise your right hand, please? Swear or affirm to tell the truth, whole truth, and nothing but the truth.
Yes, sir.
I didn't hear you.
Yes, Your Honor.
Okay, you can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes, Your Honor.
You understand that you have an absolute right to a trial?
Yes.
Mr. Berry went over your other advice and rights in the breakout room, did he not?
Yes. Yeah.
Can you understand me, sir?
Yeah, it's just a little quiet. I have my volume all the way up, but I'm getting what you're saying.
So Mr. Berry went over your other advice or rights in the breakout room, did he not?
He did, yes.
You understood those rights?
Yes, sir.
And you have any questions about those rights?
No.
You know, by taking the deal, you're going to give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to February 8th, 2025, at around 5:22 a.m. in the city of Detroit, in the area of 4th Street and Rosa Parks Avenue. Did you have an occasion on that day to be in that area around that date, that time? Did you hear me, sir?
Yeah, can you, what was the specific question? I think I live in, that was my apartment complex that I was in. I think if that answers your question.
So you were in that, were you in that area around that date,
Yes.
that time?
Yes, sir.
And did you do something out there to cause a police presence?
There was, yes, I was being very noisy.
You were being, and you were disturbing the area over around there, is that correct? I didn't hear that.
Yes.
That's yes, you keep
Yes,
breaking up.
that's a yes.
Okay, all right, you raised the thumbs up as well. And with that noise and that, would you agree that that noise that you were making out there, that they caused that you caused that police presence and it disturbed the community on that morning?
Yes.
Did you understand what I said, sir?
Yep, that's a yes.
Okay, find him guilty as charged. I'll order him to do 12 hours of community service. Is 541-901 2024, a good phone number to reach you?
Yes, Your Honor.
And do you have the number to the Southwest Detroit Community Justice Center?
Yes, Your Honor.
Your Honor,
Yes.
if I may, Mr. Gabor lives in Pontiac, and doesn't have a vehicle. Um, He indicates that he ought to be able to get down there and get this done. He wants to do it.
Okay, well, if you can get down there, we'll let him get an opportunity to do it. Come call Mr. Phillips this afternoon, set the hours up, and then I'll give you until September 17th to have the hours complete, okay?
Thank you.
All right, have a good day, sir.
You too. Bye-bye.
This is the city of Detroit versus Camilo Ospina Gomez. Case number SP 173-6676, counts 1 and counts 2. State your name for the record, please. Good morning to you.
Este es el caso de la ciudad de Detroit contra el señor Camilo Ospina. Where is he at, Your Honor?
Review. He's at review.
Okay, thank you, Your Honor. Camilo Ospina, número SP 173-66-761 and 2. SP 173-66-761 and 2.
In Spanish, Miss Fernandez.
SP 173.
En español, Emma, en español.
SP
173-66-761, cargos 1 y 2.
Good morning to you, sir. State your name for the record, please.
Buenos días, señor. Diga su nombre para que conste en el acta, por favor.
Muy buenos días, señor juez. Mi nombre es Camilo Andrés Ospina Gómez.
Good morning, Mr. Judge. My name is Camilo Andrés Ospina Gómez.
All right, good morning to you. Today is the date and time set for review. You were ordered to do 24 hours of community service. I see that you completed those 24 hours of community service. We thank you for that, and for that, we're gonna dismiss your cases, sir. If there's nothing further, have a good day.
Hoy es el día y la hora establecido para la revisión de su caso. Usted se le ordenó hacer 24 horas de servicio comunitario. Yo veo que usted aquí lo ha hecho. Le damos las gracias por ello y con eso va a ser desestimado sus 2 casos. Si no tiene más nada que agregar, que tenga excelente día y se puede retirar. Muchísimas gracias.
Bueno, muchas gracias. Dios los bendiga. Muchas gracias, muy amable por todo.
Well, thank you very much. Very kind of you. Have a good day.
All right.
Está bien, señor.
Mr. Lundy Gray.
Good morning, Your Honor.
Good morning. What brings you here today? Good morning to you. Good morning. What brings you here
Today, dinner.
You're supposed to be here tomorrow for a review, but you haven't paid.
I had to order to do community service.
And you did it?
Yes, I completed everything.
Where's the proof of it? Who did you send it to? Did you go through Southwest Detroit?
No, I got sent to Grace Community Church.
From 36 years ago. Confirming he did the community service. That's what it's all right, give me a minute, Mr. Lundy Gray. You're supposed to be here tomorrow, but if I can confirm it through them, I'll get you out of here, all right? Give me a minute. We're gonna reach out to them.
Okay.
All right, this, Mr. Berry, this is the city of Detroit versus Kari Tierra Groves, case number SP 159-24371. Appearance for the record, please.
Sir, you guys ready? Yes. Yes, podium. Thank you.
Case number 25CR42589, the state of Ohio versus Jacob Trent. Mr. Trent is before the court with his counsel, Mr. Davis, Mr. Harris, on behalf of the state of Ohio. Mr. Trent, your attorney had filed a motion for intervention in lieu of conviction on the felony charge. So in a moment, you will be asked to change your plea to guilty to that felony charge of improper handling. The court will accept your plea of guilty, but does not make a finding of guilt. Instead, I'll hold your plea in abeyance or set it aside and require you to complete a plan of intervention, which if you successfully complete that plan of intervention, then the prosecution of this case ends with no finding of guilt, and I will dismiss that charge against you. Do you understand that?
Yes.
However, if you fail to complete the plan of intervention, if you continue to break the law, the court will be able to make a finding of guilty that's based on your plea today, and then I will sentence you on that felony charge. Do you understand that?
Yes, sir.
As far as the operating a vehicle under the influence charge is concerned, you are not eligible for intervention in lieu of conviction on that charge. So upon your plea of guilty to that charge, you will be found guilty and sentenced today on that charge. Do you understand that?
Yes, sir.
How old are you?
How old am I? 36.
How far did you go in school?
Associate's degree.
So you can read and write,
Yes, sir.
and you are a citizen of the United States.
Yes, sir.
Has anyone promised you how the court would sentence you on these cases?
Promise me?
Yeah.
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation you've received from Mr. Davis in this case?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on?
No, sir.
I have in front of me two sets of documents. We're going to go through these one at a time. The first one on the felony charge on the line marked defendant on page 2, there is a signature. Did you sign this?
Yes, sir.
You read this and go over it with Mr. Davis?
I did, yes.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of improper handling of a firearm in a motor vehicle. As a felony of the 5th degree, that carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. The prison term is not mandatory. Do you understand the maximum penalty?
Yes, sir.
On that charge, you are also subject to a discretionary period of post-release control, which means that if you are sent to prison on that charge upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison by the adult parole authority for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer. And that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. If you fail to complete ILC, the court still has discretion to place you into community control, what some refer to as probation. While on community control, you will have rules you must follow as well. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
The second set of documents I have here is also a change of plea, and on page 2 of this document, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
And you read this and went over it with Mr. Davis?
I did, sir.
And again, you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to one count of operating a vehicle while under the influence of alcohol or drugs as a misdemeanor of the 1st degree. That carries a maximum penalty of 180 days in the Warren County Jail and a $1,075 fine. This also has mandatory penalties, a mandatory minimum 3 days in jail, mandatory minimum $375, and a mandatory operator's license suspension of 1 to 3 years. Do you understand the maximum and mandatory penalties involved with this offense?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty, and their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. The standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You can try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
I do, sir.
You understand that when you enter plea of guilty, you'll be waiving all these rights. We are not having a trial.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
Mr. Harris.
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about March 17th of 2025 in the city of Lebanon, Warren County, Ohio, Jacob Trent operated a motor vehicle under the influence, as well as possessing a loaded firearm that was accessible.
Mr. Davis, anything on those facts?
No, Your Honor.
Mr. Trent, did you hear the statement that he read?
Yes, sir.
Do you admit and acknowledge what he said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What is your plea?
Plead guilty.
All right, the court will make a finding. First off, let me say this. I'm going to bifurcate the traffic offense, the M1 OVI, into a separate case. On the felony charge, the court is going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and I will accept your plea of guilty. I am going to grant your motion for intervention in lieu of conviction on that case and place you into ILC for a period of 3 years. So you will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. There's no THC in any form. The treatment that has been recommended is what they call PHP, partial hospitalization. It's been recommended that I give you an opportunity to do this at this point on an outpatient basis. I want you to understand something, Mr. Trent. The purpose of this proceeding and of this intervention is to assist you, okay? So again, you seem to be downplaying your involvement with alcohol to a large extent, and I need you to be honest with your probation officer and with the treatment provider, because that's the only way we're really going to get you some assistance. This isn't punitive in nature. This is really truly meant to help you, okay? Because if you do what I ask, you do what you're told, and you get the help that you obviously need, you're going to get this felony dismissed, which is a good thing, right? All right. You're also ordered to complete the corrective thinking course, and I'm ordering you to bring in the discharge paperwork from your hospital. I want to know why you were in the hospital. You understand what I'm saying?
Yes, sir.
Was it alcohol related?
Well, that's how it started.
Okay. See, again, if you have to go to the hospital for withdrawals, you have an alcohol problem. And again, in the assessment, I think you downplay that way too much. You have a fairly serious problem, because that's not normal for people that have a few drinks to have withdrawals. You agree?
Yes, I thought I was pretty honest in the assessment. I don't.
Okay. Well, I think wasn't it downplayed quite a bit?
He reported. Sorry, one second.
I'm not denying what I think. I'm just saying
I understand that, but again.
He reported to his pretrial officer. He rated himself as a 2 slightly when asked on a scale of 1 to 5.
Okay.
How
If you're having withdrawals that require hospitalization, you're more like a 4 or 5 on a scale of 1 to 5, not a 1 or 2. Okay, just so that we're on the same page, because I'm trying to help you here. Okay. Now, with regard to the operating a vehicle under the influence, again, the court has accepted your plea, and on that charge, the court is going to find you guilty. Is there anything you want to say before I sentence you on that?
Yes, sir.
Okay. The court has considered the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to order you to serve 180 days in the Warren County Jail I'm going to give you credit for the 4 days you've served, so you have satisfied the mandatory minimum jail time, and I will suspend 176 days on the condition that you successfully complete your intervention in lieu of conviction. There is a $375 fine that I do not have the authority to waive. The court finds that you have the present and future ability to pay the costs of prosecution, so I will assess those costs against you. If you don't pay them, I can't order you to do community service until you pay those or you make appropriate arrangements for those to be paid. There is a 1-year operator's license suspension that is effective as of today, August 27th, 2025. You will be eligible for privileges to drive after you've served the first 15 days of this suspension. Okay, so you're going to have to ask for those privileges after you serve 15 days, but the first 15 days you have no privileges whatsoever. You understand? All right. Mr. Harris, did I leave anything out?
No, Your Honor. Thank you.
Mr. Davis, is there anything else?
Oh, no, y'all, just want to inform the court that his job has already informed them that because of once the OBI conviction became official, they will no longer be able to insure him, so he will be losing this.
Okay, understood. All right, so you're in the beginning of this for the first several weeks, you're going to be focusing, and Officer Kell over there is going to explain this to you in more detail, but you're going to be focused on the treatment aspect of this intervention. Okay, sir?
Yes, sir.
Do you have any questions for me?
No, sir.
All right, Officer Kell is going to want to talk to you after courts. Head back down to court services.
Thank you,
Mr. Davis.
Thank you.
Aaron, you ready?
Yes.
This is case number 23CR40803, the State of Ohio versus Felicia Maskus. Ms. Maskus is before the court with her counsel, Mr. Aldridge, Mr. Harris, on behalf of the State of Ohio. Mr. Aldridge, does your client wish to have a hearing on this final ILC violation hearing?
She's going to admit to the violations, Your Honor.
All right, Ms. Ms. Maskus, you understand you are entitled to have a hearing. You wish to waive that hearing and admit to the violation.
Correct.
All right, the court's going to find that you have violated the terms of your ILC, this being your third violation. The court is now going to terminate your ILC. And based upon your plea of April 23rd of 2024, the court now finds you guilty. Anything you want to say before I sentence you?
Yes. I am a man to my everything. That's everything. I have been dealing with a lot, but I had put my pride to the side and said I can't keep making that the blame or making that the issue. I'm back in mental health. I am very close to getting my children back. I have everything. I've been stopped smoking. I came in Friday when they came in, when I booked in. Pissed. I didn't want to cuss. I'm sorry. Peed negative. I passed it. I haven't been smoking no more. I had to stop smoking because of my asthma got messed up on me. So I'm done completely smoking. Been focused on my kids, basically trying to get them back and everything back. I have taken care of everything that I have, like in New Orleans, I have out in Hamilton County, I've taken care. I have been going to mental health classes, Tower House. I have a new therapist, a female therapist. I've just been trying to get back on the road, do everything that I can for my children and myself.
All right, the court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to find that you are amenable to community control. So I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. Do you have transportation problems?
I did at the time, but I do not no more.
Okay.
I did.
You're going to be reporting up here, correct?
That's correct, Your Honor.
Okay. So I'm going to order you. To make sure that you are engaged in substance use disorder treatment and mental health treatment. Saying that you're going to this treatment and complying with this order is not sufficient. You have to provide documentation and sign a release for probation to be able to get information from your provider. Okay.
Correct.
We just want to document this to make sure that you're doing okay. All right, so and I'm gonna, you have 29 days jail time credit as of today. I'm gonna release you on electronically monitored house arrest. How long do you want her on that?
Your Honor, I would like to start at 60 days.
All right, what I'm gonna do is have the order reflect that it is at the PO's discretion, so you don't have to come back to me. If she thinks that you're complying and doing what you're supposed to do, she will have the authority to remove the monitor at that time.
Yes, sir.
Clear?
Yes.
All right, you have any questions?
Say that again.
You have any questions?
No, sir.
All right, you can do this.
Yes, no, I'm on the move. It's for my kids. I done had too many talks. Too many people like telling me like this is not the life you wanna. Which one you wanna do?
I would agree with that.
So, and you, I'm not gonna lie. You as a judge, you my first ever judge that I ain't never cried in front of no judge. And the last time when I was in front of your face, I sat out there and I cried. And I'm like, he ain't never talked to me like that. But you mean serious. You was serious and you want better for me. So I'll take that.
I do. I don't want to see you back here in a jumpsuit. At least not an orange one. Okay?
Mm-hmm.
All right, thank you.
Thank you.
Thank you.
Mr. Moss? This is case number 25CR42696, the state of Ohio versus Billy Medina. Mr. Medina is before the court with his counsel, Mr. Moss, Mr. Harris, on behalf of the state of Ohio. We are here for sentencing. Mr. Harris, is there anything on behalf of the state of Ohio?
Your Honor, the defendant has 63 days of jail time credit. We are requesting $140 in reimbursement to Ohio State Highway Patrol for testing. In review of the PSI, I noted that the defendant has an extensive history, was out of state, and based on the activity he was involved in, obviously was involved in theft here in Ohio. It's my understanding he does not have a current residence, and I know the court gave him an opportunity to be placed into the Genesis program. My understanding is he is in compliance with that program at this time. If the court were to grant community control, we would request that it be intensive supervised probation, that he complete that program. And I think at this point that's all we have.
Anything else for probation?
Nothing further, Your Honor.
Mr. Moss?
Your Honor, I had a chance to speak with Ms. Melanie Mason, who is from the program, and she's present in the courtroom, and she reports he's done well, and that he's in the upper tier. He's done very well. He's a dorm leader, and it's also, I think, quite relevant. He's never had a program like this before, and he's succeeding. So I would ask the court to let him stay in this program. The next phase is the residential, it's called sober living, and they have a couple facilities he can move into and begin working. So there is a history there, and he was very candid. He was very candid with the court staff. Said he used meth daily up until this arrest. So that's a serious problem, and this is his first intensive treatment, and he's responding well. So we'd ask the court to fashion a sentence that lets him continue on that. And I would submit that he's already in an intensive supervision already. That if he completes all this, he should be allowed to work and be on regular probation. That's just less ways to screw up if he's otherwise in compliance, working and staying off drugs.
Mr. Medina, is there anything you want to say to me?
I just want to say thank you for the opportunity to send me to Genesis. It's opened my eyes in my life. It's helped me a lot. It's got me pointed in the right direction in life, and I would like to continue that so I'm successful.
Is there a request for restitution, Mr. Harris?
Your Honor, we tried to contact the victim in this matter. There was not a response, and I requested Ms. Kennard do that again today, and it doesn't look like we were able to reach a victim in this matter.
Okay. All right, the court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to find today, Mr. Medina, that you are amenable to community control. So I'm going to place you in the community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from use of any drugs, alcohol, or marijuana. Now, I understand that you are at Genesis and doing well, so I am going to order you to to complete that Genesis program, and you are then to go into sober living. Full circle is something that's been recommended. Is that separate from what you guys have?
Yes, we have our own sober living with Genesis. It's like phase 4, essentially. He would still be doing IOP through modern psychiatry.
Officer Fisher, is there any objection to him continuing through Genesis?
No.
Okay, so just as long as he goes into sober living following the completion of Genesis, I am going to continue you on monitor at this point for an additional 60 days. Does Genesis have a T4C class?
I don't believe we do Thinking for a Change.
Okay. I am going to order you complete the Thinking for a Change course. I think that we want to deal with some ongoing criminal type thinking. I want you to change that, the way you think about things. So you're ordered to complete the Thinking for a Change. You have 63 days jail time credit as of today, and the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to a discretionary period of post-release control, which means that if you are sent to prison on these charges, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you are sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Do you have any questions for me?
No, Your Honor.
Mr. Harris, is there anything else?
No, Your Honor, thank you.
Mr. Moss?
No, Your Honor.
All right.
At the end of the 60 days, does he have to file a motion to get off the monitor?
No, his probation officer will just submit an order to have it removed.
Okay, thank you.
All right, thank you.
Thank you.
On behalf of the defendant, Your Honor.
All right, good morning to you, Ms. Groves. For the purposes of arraignment, Mr. Berry.
Yes, Your Honor, we would waive the reading of the information and stand mute.
In our not guilty plea on Ms. Groves' behalf, give her a $0 bond. She owes many other civil infractions, 5 other civil infractions. She has one of them is related to this one, a speeding case. Give Ms. Grove an updated offer. Keep in mind, Ms. Grove, if you don't like the offer, you have an absolute right to a trial. I'm going to put you in the breakout room with Mr. Berry. Let us know what you want to do when you come out, okay?
Okay.
Those 5 additional charges, Your Honor?
Well, they're old, so we're just going to deal with them on the docket. I just let you know that just in case maybe the city will give her a break on this one because she owes that money. All right?
Yes, sir.
All right, let's go to join the room, ma'am, and speak to Mr. Berry, okay?
Thank you.
You're welcome. Let's go back on the record, past that matter. Let's go back on the record with Mr. Terry Daniel. Mr. Daniel, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client is going to enter a plea. He is willing to do community service. He would be entering a plea to allowing. The other charge was failing to signal on turn or leaving curb. I am hopeful that that could be amended to impeding. I have not received a response just yet. I'm sorry.
You reach out to Ms. Snyder.
I am awaiting a response on message. I don't think she's in the meeting.
No, she's not in the room. All right, let's pass it then and wait on that response. All right, I'm gonna start you up with Mr. Logan. This is the city of Detroit versus Walter Logan, case number SP 1259593, counts 1, 2, and 3. Appearance for the record, please, Ms. Harris.
Sharika Harris, on behalf of Mr. Logan, please state your name for the record.
Walter Logan.
Good morning to you, sir. Mr. Logan indicated to the court already he doesn't want to do community service. We're going to get Mr. Logan for the purposes of arraignment.
For purposes of arraignment, my client stands mute.
We'll enter a not guilty plea on your client's behalf to give your client a $0 bond. Mr. Logan, Ms. Harris is going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. We'll put you in a breakout room. Let us know what you want to do. Join the room, please. Let's pass the matter. Let's go back on the record with Mr. Well, I didn't even call it. Let's call the city of Detroit versus Dante Marcel Lundy Gray. This is not on the docket. It's on the docket for tomorrow, Ms. Harris. I mean, Ms. Williams Law. Case numbers SP 1203052, counts 1 and counts 2. SP 108613001, SP 1437299, counts 2 and count 3. SP 9220703, 18448572, counts 1, 2, and 3. In state of Michigan versus Dante Marcel Lundy Gray, case number SX 3425042. Mr. Lundy Gray, state your name for the record, please.
Dante Marcel Lundy Gray.
All right. Good morning to you. Today is date and time. We'll call it the date and time set for review. Mr. Lundy Gray, I told you that if you completed these community service hours, that I will close your matters out for the SP 1203052. I'm going to dismiss Mr. Lundy Gray, I'm happy to say that you were allowed to do 66 hours to clear this all up. You completed 66 hours. I thank you for that. I know they really appreciate that over at the Grace Community Church. And for that, we're going to close all your matters out. You don't owe the court any more money. And you should be able to go and get some form of, potentially you'll have clearances here. Once Mr. Mathis puts you in the system, we'll get it in the system as soon as this morning. Try to go to Secretary of State and see if you can get a valid license, Mr. Lundy Gray. Best of luck to you, sir. I wish you the best of luck and have a very good day, okay?
I appreciate that, Your Honor.
All right. Have a great one.
You have a great day as well.
Thank you. All right. Let's go back on the record with Ms. Groves. Ms. Groves, I'll give you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, we seek confirmation that she has a valid license.
That's going to be the problem. The system is down right now. Let's give it a few minutes. So sometimes it goes back up, but they said the system is down, Ms. Groves.
Okay, I'm here.
All right, let's pass it momentarily. Miss Emilia Sarmiento.
La señora Emilia Sarmiento Ovalle. Emily. ¿Necesita intérprete, señora?
Sí, por favor.
She needs intérprete, Your Honor.
Mr. Berry, this is the city of Detroit. Oh. City of Detroit versus Emmy Ovalle. Case number SP1763960-1, SP1763998, counts 1 and counts 2. Appearance with record, please.
Este es el caso de la ciudad de Detroit contra la señora Emily Sarmiento Valle. El número de caso SP 176-39601 y SP 176-39981, cargos 1 y 2. Sus comparecencias, por favor, señor Berry, para que consten en el acta.
Elwood S. Berry Jr. on behalf of the defendant, Your Honor. State your full name.
Berry Jr. representando a la acusada, su señoría. Señora, por favor, diga su nombre completo para que conste en el acta.
Emily Juliana Sarmiento Ovalle.
Emily Juliana Sarmiento Ovalle.
Good morning to you, ma'am. For purposes of arraignment, counsel.
Buenos días, señora. Para los propósitos de la lectura de cargos que desea hacer su representada, señor abogado.
We would waive the reading of the information and stand mute, Your Honor.
Su señoría, nosotros vamos a ceder la lectura formal de los del documento y vamos a permanecer en silencio.
Okay.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Ms. Ovalle, Mr. Berry's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. I'm gonna put you in a breakout room with them. Let us know what you want to do when you come out, okay?
Señora Valle, nosotros voy a introducir una declaración de no culpabilidad en su nombre y voy a imponer una fianza de $0. Su abogado le va a conseguir una oferta de resolución con la fiscalía. Si a usted no le gusta esa oferta, usted tiene el derecho de ir a juicio. Por favor, únase a la sala de consulta privada cuando vea la invitación en su pantalla.
Okay.
Por favor, apriete Join, unirse.
She's in there. All right, let's pass the matter. Let's go back on the record with Mr. Walter Logan. Mr. Logan, I'm giving you an opportunity to speak to counsel. What your client want to do?
My client again is unable to complete community service. He does wish to enter a plea. The recommendation would be he completes it 1 count improper plea. I advised him that today was just for community service and that he may have to get a new court date.
Because Mr. Logan is here and he will be with me, and that this officer's offer is not one that would be anything different than he would have received outside of the court date, I'll allow him to pay the fine. You want to take the deal, sir?
Yes, sir.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
And down. You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
I do.
You understand that you have an absolute right to a trial?
I do.
Ms. Harris went over your other advice or rights in the breakout room, did she not?
She did.
Did you understood those rights?
I do.
Do you have any questions about those rights?
I do not at this time.
You know by taking the deal, sir, you're gonna give those rights up?
I do.
Has anybody offered you anything other than what's been stated in the record?
No, sir.
Let me draw your attention back to October 4th, 2021 at around 12:02 p.m. in the city of Detroit, in the area of 8 Mile and Hoover. Did you have an occasion on that day to come in contact with the Detroit Police Department?
I believe so, yes. Yes, sir.
You call that, it was you were in a 2000?
Because the first count is allowing, I'm not 100% certain that he would have been in the car.
Okay, maybe not. So, did you own a 2014 Dodge on that day, sir?
I did.
And was that Dodge operable at that time?
At that time, it was operable.
And did you have any insurance on that vehicle at that time?
I did not.
Very well. Find your client guilty of the amended count of improper plate. $240 will be the fine. I'll dismiss upon payment. I'll waive the warrant fees. And stipulate the proper cause. We'll discuss the other two matters now.
So stipulated, Your Honor.
All right, $240, Mr. Logan. When can you pay?
Can I please make an arrangement? I'm going through a sort of financial hardship at the moment.
Why did you just do the 12 hours of community service then?
I'm no good for the community service. I just had surgery, lost a kidney, and I'm going through some health issues at the present time, sir.
Well, they have a community service, you know, maybe somewhere, some phone calls, or they can accommodate you with some health issues if you let them know that.
Your Honor, this is Ms. Montejo, we can absolutely accommodate him. We could put him at the front desk and he can be the greeter. And then that way it could solve his problems financially and, you know, we can accommodate him.
I mean, do you want to do that or do you want to just pay?
I would just pay. Currently, I am employed, getting back to work with Stellantis on 8 Mile and Mile. We have just returned back to work due to part shortages.
All right, here we go. We'll pay it by September 17th, 2025. I'll say September 19th, 2025. Come back in that morning at 8:25. If it's paid, we'll dismiss the case. I'll mark the file, allow payment plan. So either you do one or two things. You pay it at any DivDad kiosk in the city of Detroit. I told you, you can upload the DivDad after your phone, or come on down to the courthouse and pay it in person. Those are the two best ways I can tell you to pay it. Or you come on down to the courthouse before the 19th of September and get into a payment plan, okay?
I would rather come down and personally as soon as possible and pay it in person. Thank you.
All right, thank you so much. If there's nothing further, best of luck to you. Your next court date is September 19th. If it's paid all the way in full, you don't have to show back up. But if it's not paid, I need to see you, okay?
Okay, and again, please, you said 240, correct?
40, yes. We'll dismiss the case upon payment.
Thank you, sir. I appreciate your time.
Best of luck to you, Mr. Logan, and we'll be praying for your continued good health and your recovery, and congratulations on getting back to work.
Thank you. I appreciate you.
All right, have a great day.
You too.
Did we get an answer on Mr. Daniel?
We did, Your Honor. So long as he does not have a CDL, that amendment to impeding is okay.
Let's go back on the record with Mr. Terry Daniel. Mr. Terry Daniel, I'm giving you an opportunity to speak to counsel. Counsel is allowing.
One count of allowing. And Mr. Daniel, do you have a CDL?
No.
And there would be an amended count of
Thank you. Please be seated. Mr. Tiggs, I see you're holding the verdict forms. Are you the foreperson of the jury, sir?
Yes, sir.
Can you tell me, has the jury reached a verdict?
Yes, we have.
All right, would you please hand the verdict forms to Mr. Logs? Mr. Cummings, would you please rise for me, please, sir? In the matter of the state of Ohio versus Anthony Cummings, verdict form as to count 1 reads as follows. We, the jury, being duly impaneled, sworn or affirm, find the defendant, Anthony Cummings, not guilty of murder as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. As to count 2, we, the jury, being duly impaneled, sworn or affirm, find the defendant, Anthony Cummings, not guilty of felonious assault as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. As to count 3, we, the jury, being duly impaneled, sworn or affirm, find the defendant, Anthony Cummings, not guilty of aggravated robbery as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. You may sit. Does the state wish to have the jury polled?
No, Your Honor.
Does the defense wish to have the jury polled?
No, Your Honor.
All right, ladies and gentlemen, at this time, that concludes your service in this case and your jury service for this term. If you get another jury notice, just contact Ms. Yazel and she'll release you for further service. All of the prior instructions and admonitions I've given you about discussing the case and everything, you are now released from. Sometimes the attorneys would like to talk to you after the case. If any of you don't want to stick around and talk about the case, just hang out in the jury room. But I'm going to release you back to the jury room. Mr. Logs is going to return your electronic devices, and I'll be back shortly just to thank you personally for your service. Okay?
All rise.
Anything else?
No, Your Honor.
Anything else?
No, Your Honor.
All right. Thank you all.
Do you swear to tell the truth, whole truth, nothing but the truth?
Yes, Your Honor.
You can put your hand down. Do you understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Ms. Harris went over your other advice or rights and break down one, did she not?
Yes.
You understood those rights?
Yes.
You have any questions about those rights? Any questions about the rights, Mr. Daniel? He froze. Mr. Daniel? I believe he froze us. Give me 1 second, please.
Thank you.
Mr. Daniel, did you get your communication back?
Yes.
Did you, where was I? Let's go back on the record with Mr. Daniel. You understand, Ms. Harris went over your advice and rights, did she not?
Yes.
And you understood those rights, correct?
Yes.
And you know by taking the deal, you're gonna give those rights up, correct?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
All right, let me draw your attention back to July the 20th, 2025, around 5:16 p.m. in the city of Detroit, in the area of Fort and Woodmere. Did you have an occasion on that day to be have contact with the Detroit Police Department on that day?
Yes.
Were you operating a motor vehicle?
Yes.
Officer asked you to produce valid the driver's license. I think he went blank again. Let me turn your camera off. I turned your camera off. Officer asked you to produce a valid driver's license.
Okay.
Did the officer ask you to produce a valid driver's license?
Yes.
And you couldn't do so, could you? And why is that?
I didn't have, my license was suspended.
Very well. Find your client guilty of the amended count of allowing, order them to do 12 hours of community service. I'll dismiss upon payment. Stipulate to the face of the ticket on your client's behalf as an active factual basis for that responsible plea counselor.
So stipulated, Your Honor, stipulates a probable cause for the dismissals.
All right, with those stipulations, I'll find you responsible for the amended count of blocking traffic. In lieu of fines and costs, it'll be 6 hours of community service. And I'll dismiss the other matters. Is 33729-8144 the best number to reach you? And do you have the number to the Southwest Detroit Community Justice Center?
Yeah.
All right, I'm gonna give you until September the 17th to complete 18 hours. Give Mr. Phillips a call this afternoon to set the hours up. If you don't have anything further, sir, I wish you the best of luck. Have a very good rest of your day, okay?
All right, thank you, Your Honor. You have a blessed day as well.
You have a good one. All right, Ms. Harris, this is the city of Detroit versus Guillermo Lopez Jr. Case number is SP 168-58362, SP 176-3823, counts 1 and counts 2. Appearance for the record, please.
Llamamos ahora el caso de la ciudad de Detroit versus Guillermo López. Números de caso SP168-58362 y SP176-3823, cargos 1 y 2. Que todos digan sus nombres para que consten en el acta, por favor.
Mi nombre es
Guillermo López.
My name is Guillermo López.
Cherica Harris on behalf of Mr. Lopez.
Y soy Cherica Harris representando al señor Guillermo López.
Your Honor, dismiss one tail. This client is a repeat client.
Hablando la señora Buentillo, y este cliente es alguien que ha vuelto.
Yeah, I know. Today is the date and time set for a review on the SP 168-58362.
Sí, y tengo entendido que él está aquí para una revisión de su caso. Este es el día y la hora que habíamos fijado para tener eso para uno de los casos.
You completed the community service for that, so thank you for that. And we're going to dismiss your case for that case.
Y me refiero al caso 168-58362. Usted cumplió sus horas de servicio comunitario para ese caso, así que ese caso queda desestimado.
And the other cases are show cause. We'll arraign them on the show causes now.
Y los otros casos que él tiene son para mostrar causa. Así que vamos a proceder con esos asuntos ahora.
For purposes of arraignment, my client stands mute.
Muy bien, así que para el propósito de lectura de cargos, mi cliente va a guardar silencio.
We'll enter a not guilty plea on your client's behalf. We'll give your client a $0 bond. Get Mr. Guillermo an updated offer. Keep in mind, Mr. Lopez, an updated offer. Keep in mind, if you don't like the offer, Mr. Lopez, you have an absolute right to trial.
Muy bien, así que voy a procesar una declaración de no culpable para su cliente, darle una fianza de $0. Consígale, señora abogada, una oferta de resolución actualizada, déjele saber lo que es. Y señor, sépase usted que si usted no está de acuerdo con la oferta de resolución de parte de la fiscalía, usted tiene todo derecho de ir a juicio.
Ok.
Ok.
Join the room, please.
Acepte la invitación para pasar a una sala privada, donde dice join o unirse, toque ahí.
On the telephone at 248-242-2231. Good morning to you. What is your name, please? Ms. Anara Gordon?
Yes, I'm sorry.
Good morning to you. You were supposed to do community service and you didn't do it.
I did, sir.
You did?
Yes.
All right, Mr. Phillips, on the sheet here. All right, this is the city of Detroit versus Anara Karen Gordon, case number SP1506302, counts 1 and counts 2. Appearance for the, state your name for the record, please.
Inara Gordon.
All right, good morning to you, Ms. Gordon. Day is date and time set for review. Mr. Phillips.
Your Honor.
I have on this sheet that Ms. Gordon did not do any community service hours.
Not to us.
Be updated.
He said not through them.
So who did you do the community service through, Ms. Gordon?
Last time I saw you, a lawyer had gave me a number to call a local church that deals with people in community service. And I was at the church. They gave me a paper.
Who told you to do that? Why would the lawyer? Who is this lawyer that you spoke with?
I think it was something Brown. I threw the paper out with his name and number on there, but he gave me a number to call a local church.
That wasn't through this court, was it?
Yep. Last time I saw you, a lawyer spoke to me about, because remember I was telling you I couldn't get to it. And then,
okay. So all right. See, this is not Mr. Berry. Is that Mr. Berry?
I think so. It was something like Brown, Berry. It was something, I don't know.
And where's the paperwork that you have?
I have it. They told me that I was supposed to take it up to 36th District Court. They signed it. Like I had a time card for my community service and all that.
Where is it?
I have it with me. They told me I would have to take it up to the court, but I was just trying to see what you said first.
Well, first of all, I didn't agree to you going to another place to do the community service. I don't see that I did. And you've been back here a number of times. I told you to go through Southwest Detroit Community Justice Center. That way we wouldn't have this issue. Where is the church in the city of Detroit?
Yes.
What's the name of the church?
Missionary Baptist Tabernacle. I don't know. Maybe I should grab the paper.
I think so.
It's Tabernacle Missionary Baptist Church.
Let me see what you have.
It's my time card.
How do we verify that?
Your Honor, I recognize the timesheet as one of our partners.
That is one of your partners?
Yes.
Okay. Okay. Can you? Let's see the hours. Let's see the hours. How many hours did you do?
I did more 30. I did more than 24. I did 30.
Okay, well, you got, all right, that's good. I'm gonna say that, we appreciate you going above and beyond. Can you recognize the hours? Can you get us that time sheet, ma'am, so we can put it in your file?
Yes, sir.
All right, I'm gonna call it good, Ms. Gordon. I'm gonna thank you for your community service. Get us the hours so we can put it in your file. We're gonna dismiss these 2 cases, okay?
Okay, thank you.
All right, best of luck to you, ma'am. Have a very good rest of your day.
Thank you, you too.
All right, let's go back. Let's go back on the record with Ms. Ovalle. Ms. Ovalle, I've given you an opportunity to speak to council. Council, what you plan want to do?
Vamos a volver para que conste en el acta, señor, con el caso de la señora Ovalle. Señor Ovalle, le di la oportunidad de hablar en una sala de consulta privada con su abogado. Señor abogado, ¿qué desea hacer la señora Ovalle?
Your Honor, my client would avail herself of the people's offer to allow her to enter a plea to allowing for the road closed matter and blockading for disobeying a traffic device. The no license matter to be dismissed.
Mi cliente se quiere adherir al acuerdo ofrecido por la fiscalía, que es que le van a quitar el cargo, se va a desestimar el cargo de no tener licencia y se va a declarar de los otros 2 cargos de no haber, de haberse metido por una vía que estaba cerrada y haber no obedecido una señalización de lo mismo. Y eso va a ser enmendado porque dejó que alguien sin licencia manejara y porque estaba bloqueando el tráfico. Y los 2 casos van a ser desestimados una vez se cumplan las horas de servicio comunitario.
You want to take the deal, ma'am?
Señora, ¿y ese es el acuerdo que usted quiere tomar? Tiene que abrir su micrófono, señora Sarmiento. Señor Ovalle, abre el micrófono.
Yes.
Yes.
Can you raise your right hand, please?
¿Puede levantar su mano derecha, por favor?
You swear or affirm to tell the truth, whole truth, nothing but the truth?
¿Usted jura o afirma decir la verdad, solo la verdad y nada más que la verdad?
Yes.
Yes.
Can you put your hand down?
¿Puede bajar su mano?
You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Señor, ¿usted entiende que la máxima penalidad para este tipo de delito podría ser hasta 93 días de cárcel y hasta $500 de multa?
Sí.
Yes.
Do you understand that you have an absolute right to a trial?
¿Y usted entiende que usted tiene absolutamente el derecho de ir a un juicio si así lo quisiera?
Sí.
Yes.
Mr. Berry went over your other advice and rights in the breakout room, did he not?
Y mientras que estaba en la sala de consulta privada, su abogado le dejó saber todos sus derechos.
Yes.
Yes.
You understood those rights?
¿Y usted entendió esos derechos?
Yes.
Yes.
You have any questions about those rights?
¿Tiene alguna pregunta acerca de esos derechos?
No.
No.
You know, by taking the deal, you're going to give those rights up?
¿Y usted entiende que tomando este acuerdo que le están ofreciendo de resolución, usted está cediendo, está renunciando a esos derechos?
Sí.
Yes.
Has anybody offered you anything other than what's been stated in the record?
Y aparte de lo que ya hemos dicho aquí y que consta en el acta, ¿alguien más le ha ofrecido alguna otra cosa, señora?
No.
No.
We draw your attention back to July the 30th, 2025, at around 9:03 a.m. in the city of Detroit, in the area of Warren and Jeffries. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Señora, le quiero llevar su atención al día, la hora y el lugar de los hechos, que fue el 30 de julio del 2025, alrededor de las 9:03 de la mañana, en las calles de Warren y Jeffrey en la ciudad de Detroit. Ese día, esa hora y en ese lugar, ¿la para usted un oficial de policía?
Sí.
Yes.
Were you operating a motor vehicle?
¿Y está usted manejando un vehículo automotor?
Sí.
Yes.
The officer asked you to produce a valid driver's license.
Y el oficial le pidió que le mostrara una licencia de conducir válida.
Sí.
Yes.
You couldn't do so, could you, ma'am?
Pero usted no se la pudo mostrar, ¿verdad, señora?
Verdad.
That's true.
Why is that?
¿Por qué no se la pudo mostrar?
Porque en el momento no había podido solicitar la licencia porque no tenía los documentos pertinentes para hacer la solicitud. Como le expliqué en la sala ahorita anteriormente, ahorita estoy en el proceso porque ya tengo los documentos para poder solicitarla.
Yes, because by that moment I didn't have the documents required to get my license, but as I explained my lawyer in the private room, I already have all my documents, and tomorrow I have my test to take my license.
All right, we'll find your client guilty of the amended count of allowing 12 hours of community service. I'll dismiss upon completion. Stipulate the proper cause, we'll dismiss the other matters now.
Está bien, entonces yo voy a encontrar a su cliente culpable del cargo enmendado de que dejó que alguien sin licencia manejara, y le voy a poner 2 horas de servicio comunitario y lo voy a desestimar una vez que esté completada, y después de que su abogado establezca la causa probable, voy a desestimar los otros 2 cargos.
So stipulated, Your Honor.
Estipulación hecha, su señoría.
All right. All right, it's 313-383-4317, the best phone number to reach you at, ma'am?
Este es 1-338-342-17.
Sí.
¿Tu teléfono?
3-1.
Sí, diga.
3-1-3, bueno, 313-303 4217, yes?
313-303
4217, yes.
Sí.
313-303-4217, correct?
Yeah.
313-303-4217, ¿correcto? Sí.
Sí.
Okay,
Yes.
I'm gonna order you, Ms. Benteo call this afternoon. 6 hours up. I'm gonna give you until the 17th of